I'm just checking in. This is John Madden. I'll be our presiding judge today. We're a little early. I'm just kind of checking. It looks like we got about 6 minutes till we get started. We've got most of our scoring panelists in. We have one that may be appearing, so we'll give her until 6 before we get started. I'm just checking in. This is John Madden. I'll be our presiding judge today. We're a little early. I'm just kind of checking. It looks like we got about 6 minutes till we get started. I got to fix that feedback. Well, that was ridiculously annoying, but I got that figured out, so we won't be having it replaying what I'm saying every 10 seconds. But on that, relax for a few minutes, and in about 5 minutes, we'll start at 6 o'clock. And while we wait, this is for our scoring panelists. I just want to make sure that you've got your score sheets ready to go, and we'll enter all the information in terms of the participants and the team codes once we get started in about 3 minutes. Excellent. It looks like we've got everybody ready to go. Before I get started, I just want to check with our competitors. Are you all ready to start?
Yes, Your Honor.
Yes, Your Honor.
Excellent. All right, and I see that we've got our two scoring panelists, John Ury and Wayne Slaughter. Are both of you ready?
Yes, Your Honor.
Yep. Yes, Your Honor. Thank you.
Thank you both. All right, and then I think, and I always get off on this, it looks like we have all our witnesses from our competitor standpoint. Does it look like we've got all of your witnesses as well? It looks like the Brady Bunch. That's perfect. All right, we're in good shape. In that case, we'll go ahead and get started. First, we're here for the second round of this year's Summit Cup. Let me go ahead, and what we'll do is we'll start with entries of appearances, and we'll also let our scoring panelists get those entered in their score sheets. But if I can begin with the entries of appearances, starting with the plaintiff, please.
Yes, Your Honor. On behalf of the plaintiff, Cam Donaldson, my name is Justin Pyron, and my co-counsel is Elizabeth Nielsen.
All right, and entries of appearance for the defense.
Yes, Your Honor. My name is Hannah Parman on behalf of the defendant, Karen Baja, and I'm joined by my co-counsel, Alexandra Bartos O'Neill.
Good evening.
Thank you. Sorry, thank you very much. First, we should always check. I don't think this is the case, but for our scoring jurors, do any of you know either one on either team to a degree that it would affect your ability to provide an unbiased evaluation?
No.
No, Your Honor.
Thank you. All right. In that case, we're in good shape then. I think we've got no conflicts. We're ready to start. Let me check with the plaintiff. Is the plaintiff ready to proceed?
Yes, Your Honor. The plaintiff is ready to proceed to pretrial.
All right. Is the defense ready to proceed?
Yes, Your Honor.
All right. Before we get to our pretrial matters, if I can have all of our competitors and witnesses, please raise your right hand. And please indicate please indicate by saying I do if you swear to abide by the rules of this proceeding and to conduct yourself in a manner that is honorable to the forum.
I do.
I do.
I do.
I do.
Thank you very much.
I do too.
Perfect. All right, in that case, I'll go ahead and call the case, and I'll call case number 082263, Cam Donaldson versus Karen Baja. And let me begin with the plaintiff. Are there any housekeeping matters?
Yes, Your Honor. First, can the parties assume that all witnesses will be considered constructively sworn in?
That's the easiest thing to do. So rather than try to swear everyone in, we will presume that that's already been accomplished. And so the witnesses will not have to be re-sworn in before their testimony.
Yes, Your Honor. Secondly, can we assume that all objection battles will be constructively heard outside the presence of the jury?
Precisely. We'll presume that any discussions other than simply making the objection would be heard at the bench.
Yes, Your Honor. Due to the virtual nature of this competition, would it be appropriate for us to be remaining seated during any objection battles that might occur?
I am comfortable with that. Whatever the easiest approach for you is, if you're already standing and wish to do so, you may, but I'm not going to require you to stand during the discussion because of the format. Yes,
Your Honor. And finally, does this court allow the zooming in or manipulation of exhibits during the course of a direct examination in order to emphasize certain parts of admitted exhibits?
Let me first check with the defense any objection to that procedure.
No objection, Your Honor.
And other than that, I absolutely do. My thought is that they're your exhibits and your demonstration and presentation. And so if you need to zoom in on a portion, that's completely acceptable.
Yes, Your Honor. With that, the plaintiff is ready to move to motions in limine.
All right. Any housekeeping or preliminary matters by the defense?
Yes, Your Honor. First, are experts required to be tendered in this jurisdiction?
Yes, the presumption is that if you move to tender them, I would expect that to be done. Yes, thank you.
And it is our assumption, and we discussed this briefly when we met with opposing counsel earlier, that none of the witnesses in this case are sequestered as to our advisory witnesses and to our parties to the case. Is that your understanding as well?
I hadn't actually thought that far through it, but I think if both parties are comfortable with the fact that since each of you has a party and an expert or advisory witness, If that's acceptable with both of you, that's fine with me. Any objection in terms of that by the plaintiff?
No objection, Your Honor.
So we'll assume that none of the witnesses who will be testifying today are sequestered.
Yes, Your Honor. And does the court have any preference for handling exhibits for the purposes of introducing them? For example, we've been identifying them using a Bates number, as well as the name of the document, and just referring the witness to that document instead of showing to opposing counsel, as that's not entirely possible in this format.
I understand. And I want to make sure I'm on the same page. There's different ways we could do this. My expectation would be that if you refer to the exhibit, we all have copies of that exhibit, so you wouldn't have to show it to opposing counsel first, or I guess technically try to somehow show it to the witness. They should look at their copy, and then when it's admitted, leave it to you in terms of how you would display it for the jury at that point.
That would be our preference, Your Honor, if that's all right with plaintiff's counsel.
All right. Unless there's an objection, we'll go ahead and say that's the expected practice.
And then, Your Honor, when we were wondering if you had any preferences on whether the non-participatory counsel, those not directly interacting with a witness at a certain time, could have their videos off, just to allow greater focus by the jury.
I think that tends to work better. Two things. It seems to assist in terms of the focus of the jury, assist the bandwidth issues. So my expectation would be that we'll have examining counsel, opposing counsel, the witness, and the court should be the only ones with the video at any given time.
Yes, Your Honor, thank you. And then I know you said that we would constructively approach. Would you like us to ask to approach when we object before we make a speaking objection, or will it be assumed that we have at that point constructively approached if we become speaking?
That's an excellent clarification. My presumption will be that if we're speaking at a lengthy period of time, that we are at the bench, so you do not need to ask to approach. You certainly could, but it's a way of saying if we have the argument about the objections, you don't have to ask to approach first. We'll assume that that would be outside the hearing of the jury.
Thank you, Your Honor. With that, defense is ready to proceed to motions in limine.
All right, let's go ahead and begin then with motions in limine. We'll start with the plaintiff. Any motions that you have?
Yes, Your Honor. The plaintiff moves in limine to enter into evidence a request for a restraining order that was filed by Lou Donaldson. May I be heard?
Absolutely.
Your Honor, as a bit of background in this case, this is a wrongful death action where the plaintiff has accused the defendant of being the cause of the death of her late husband, Lou Donaldson. Before his disappearance, he had filed a request for a restraining order, and that restraining order goes directly to the motive and plan of the defendant to ultimately take his life. Therefore, under Rule 402, it should be admitted into evidence at this time.
Any opposition by the defense to the restraining order?
Yes, Your Honor, we object to its admittance under evidence rule 403, 404, and also hearsay 801. Shall I explain?
All right, go ahead, I'll let you explain.
Now, the request for the temporary restraining order first contains several statements written by Mr. Lou Donaldson. Those three main statements are that Karen Baja threatened him, that he wants a divorce from her, and also that he does not feel safe around her. All of those statements are statements of hearsay by Mr. Donaldson, and they do not end it. And I believe that opposing counsel is attempting to have them in for the truth of the matter asserted. And furthermore, this document, we do not know the substance behind this document or the factual basis behind this document. And we believe that if this were to be entered, it would be substantially more prejudicial than probative to the jury, as they may give extra weight to the nature of this document and assume that Karen Baja had an intention to kill Mr. Donaldson when we do not know the circumstances of that. And furthermore, we believe, in addition, under evidence rule 404, that plaintiff's counsel is attempting to use the specific statement of Ms. Baja threatening to kill him, and that Mr. Donaldson didn't feel safe around Ms. Baja, to show that because it happened in the past that she had the intention of killing him in this particular situation in the mid of August of 2012.
Any response by the plaintiff?
Yes, Your Honor. Starting with the hearsay objection, first of all, one of these statements was a statement that Ms. Baja had made to Mr. Lou Donaldson and therefore is not hearsay because it was uttered by the party opponent. For the other two statements, it goes directly and fits squarely in 8033, the then existing mental, emotional, or physical condition of Lou Donaldson at the time that he made these statements. As for the 403 objection, this is not substantially more prejudicial than it is probative because it goes directly to that plan and motive that Ms. Baja had to take Mr. Donaldson's life, which also leads directly into the 404b2 exception to the character evidence objection that opposing counsel had made. Because this is describing the plan and motive of Ms. Baja, it is not being used for the purpose of improper character inferences. It's being used to show the jury how that motive and how her plan ultimately played out.
And let me make sure I understand that in terms of two things. What was the timing of the request in terms of the restraining order versus the time that Mr. Donaldson's alleged to have disappeared in this case?
The restraining order was filed on June 12, 2012, and then Mr. Donaldson was last seen on August 17th, 2012.
And so in a sense, to go into the defense argument, how would that not be character evidence or propensity in terms of that there's an ongoing, not ongoing threat, that she's threatened him in the past and is therefore likely to have been responsible for his disappearance in the future?
Because, Your Honor, this is actually going to the other purpose, which is to show her plan and her motive. The motive being that Mr. Donaldson had requested her for a divorce at that time, and the plan being the actual threats that she was making against Lou Donaldson's life at that time as well.
That answers my question. Ms. Bartos-Neal, I opened some areas. I usually don't go back and forth too much, but any reply in light of my question?
Yes, Your Honor, we do have a reply. First of all, we want to note that although Karen Baja is a party opponent in today's case from the plaintiff, and her statement itself is not hearsay, the fact that this is being relayed by Mr. Donaldson involves a second layer of hearsay and therefore would still be inadmissible under 801. And as for the evidence rule 404, the propensity, Your Honor, we still believe that the fact that Ms. Baja allegedly said this statement in the past would still indicate that there would be a propensity for her to be responsible for Mr. Donaldson's crime, or for Mr. Donaldson's disappearance in the middle of August of 2012. And the reason being is that we don't have the context for what that statement was said or whether or not Ms. Baja had reacted specifically to any circumstances or had reacted in a way that she felt that she would lose or feel motivated to kill Mr. Donaldson as noted by that statement. And therefore, we still believe it is character evidence under 404.
Mr. Pyron, let me come back to you. Any additional arguments, I'm sorry, not additional arguments, any additional motions at this point on behalf of the plaintiff?
Yes, Your Honor, but for clarification purposes, are you withholding ruling on this particular motion at this time?
Exactly. My plan is to go ahead and rule kind of en masse, so to speak. So I'll hear all the arguments and then issue a ruling as to all of them.
Yes, Your Honor. My co-counsel will present the next motion in limine.
Thank you very much. Go ahead.
Your Honor, thank you. The plaintiff moves in limine to bar from introduction into evidence any statements by opposing counsel in the presence of the jury or any witness testimony regarding Lou Donaldson's occasional practice of flying airplanes without logging a flight plan. May I be heard?
Please.
In discovery, the plaintiff has learned that the defense counsel may seek to introduce evidence to suggest that Mr. Donaldson flew an airplane without logging a flight plan on the weekend he disappeared. The plaintiff moves to bar the introduction of this evidence under Rule 404, which prohibits improper character evidence, including improper propensity inferences. We believe that if this evidence was introduced, that it would cause the jury to make that improper propensity inference, that they would assume that just because Mr. Donaldson had occasionally flown planes without logging flight plans before, that is what he did on this weekend.
All right, let me go to the defense then. Your response in terms of the 404 issue.
Yes, Your Honor. Evidence of Mr. Donaldson habitually flying out and not logging a plan is permissible under evidence rule 406 as an example of his habits. Now, we're not going to argue an inference that because we're not attempting to argue an inference that because he didn't log a flight plan in the past that he didn't in this particular instance, but simply show that he had certain habits associated with his hobbies of flying planes and the habits surrounding that. And therefore that would be permissible under evidence rule 406.
And in terms of it being a habit, does the defense have a position in terms of how regularly it happened?
Yes, Your Honor, I believe we're going to get this testimony from we're going to elicit this testimony from people who knew Mr. Donaldson well and would be able to testify to his habits and how frequently that occurred.
I may have asked that bad. Oh, you plan that they'll testify as to how often it occurred?
We plan to elicit testimony about the frequency. Yes.
And
Am I
what is your
misunderstanding your question?
anticipation as to what they'll say?
We believe that the witnesses that we're going to ask these questions to will simply give a general testimony about how Mr. Donaldson would often not record his flight plan because his license was suspended. That's the extent of the information.
All right, I'll come back to the plaintiff. Any reply?
Well, this is clearly not habit. It did not happen with the regularity or specificity that Rule 406 for habit requires. So it cannot be admitted under the habit exception.
All right, I think I've got the information I need for the ruling. Any additional motions eliminated by the plaintiff?
No, Your Honor.
And were there any motions eliminated by the defense?
Yes, Your Honor. The defense would like to exclude mention of Ms. Baja's refusal to undergo a polygraph, which is testimony that we believe Ms. Pride is available and privy to under evidence rule 402 or 403. As an offer of proof, this refusal to take a polygraph test was in lieu of the police investigation when Mr. Donaldson first disappeared. We believe this information is substantially more prejudicial than it is probative, as people refuse to take polygraphs for numerous reasons besides inferring any form of guilt or unfavorable results due to the skeptical and unreliable nature of the polygraph itself. And therefore, we ask that this mention of the refusal to undergo a polygraph be excluded.
Plaintiff's response to that motion.
We have no objection to this motion, Your Honor.
That makes the ruling easy. That'll work. Any additional motions on behalf of the defense?
Yes, Your Honor. We also move to exclude evidence of Ms. Baja's misdemeanor assault under evidence rule 402, 403, and 404. As an offer of proof, this misdemeanor assault was a conviction that Ms. Baja got when she was a juvenile. It happened over 10 years ago and doesn't go to show any, it has nothing to do with dishonesty or truthfulness, and therefore we ask that be excluded as well.
And does the plaintiff have a response position regarding that motion?
We have no objection to this either, Your Honor.
All right. And then finally, any additional motions eliminated by the defense?
Yes, Your Honor, one last one. We move to exclude testimony of Taylor Pride's phone call with Samantha Lane, as that is inadmissible hearsay under ER 801, and we do not believe it falls under any exceptions or evidence rule 804 as an unavailable witness.
And could you give me more details in terms of the phone call?
Yes, the phone call was occurred in Taylor Pride's investigation of an analysis of the will that was presented by Ms. Baja. She contacted one of the witnesses on that will, Samantha Lane, and in that phone call, Samantha Lane told her that she was threatened by Ms. Baja and coerced into signing that will. The testimony of that phone call we would say is inadmissible hearsay.
Plaintiff's position in terms of that motion?
Yes, Your Honor, we would object. As this Taylor Pride, we expect to be entered in as an expert witness in today's case. Under Rule 703, she would be able to make testimony that informed her conclusions, even if it's based on inadmissible hearsay. So she would be able to testify to that phone call with Samantha Lane under 703.
Doesn't 703 say that an expert can rely on admissible evidence, but the proponent can't introduce it unless they meet other requirements? I'll let you address that in terms of why it would come in past that on 703.
Because, Your Honor, we are not asking to enter in a specific transcript that Taylor Pride had of this conversation with Samantha Lane, just going to how it impacted her ultimate conclusions in her report. So we're not using it for the truth value of that, but rather how that ended up affecting the conclusions that she came to in her investigation of the disappearance of Lou Donaldson.
Understood. Any reply by the defense?
Yes, Your Honor, we understand the nature of Evidence Rule 703 as it relates to experts. However, our concern is that Ms. Pride is going to be a conduit for this hearsay and attest to its reliability. If opposing counsel truly wanted these statements to come in, they would have had to obtain or call Ms. Lane herself to testify to those statements. And as a result, we believe that even if these statements were to come in, they would have truth value asserted with them.
All right.
May I be heard in
Finally,
response?
any additional? Actually, given that last offer, absolutely, I'll go ahead and let you respond as well.
Yes, Your Honor. Opposing counsel just described what would go to weight, not admissibility of Ms. Samantha Lane's statements. Ms. Pride will be available for cross-examination, and if opposing counsel has a problem with the credibility of Ms. Lane's statements, that is ripe for exploration on cross-examination. It should not be determinative of whether or not Ms. Lane's influence on Ms. Pride's ultimate conclusions in this case should be admitted.
All right. Actually, I appreciate the clarification. That was a new issue. Any additional motions eliminated by the defense?
No, Your Honor.
All right. Actually, all the motions are well argued, and I appreciate it. I think I understand all of those. I'll make at least preliminary rulings. If circumstances change, it could be called to my attention outside the presence of the jury. But in terms of the statements with the restraining order, at this point, I'm going to begin by at least denying the motion to restrict that in limine. It may still not be admissible, and there can be contemporaneous objections under the circumstances. What I'm hearing in terms of the description of wanting a divorce or feeling threatened or not feeling safe, I would agree that those are 8033 exceptions. The statement made to Mr. Donaldson by Ms. Beja, her statement obviously is non-hearsay. We have hearsay within hearsay. And to the extent it puts the position in context, under all of those circumstances, presently not going to exclude it under 801 as hearsay. And I think given the fact that it goes to issues that are potentially central to the case, I'm going to find that the probative value is fairly significant and high and is not substantially outweighed by the risk of unfair prejudice. And so under those circumstances, I'll decline to eliminate that in limine. As to the practice without a flight plan, though, I would agree that I think the only benefit and value to that at this point is suggesting that it's happened on certain occasions, and therefore he acted in conformity with that character. In other words, he has a character potentially of forgetfulness or of not filing it, or even in this case, what I'm hearing is character for not filing it because his license was under suspension, so it's a negative action. That it's not a habit in the sense that he does it mindlessly without realizing it, and we can rely on the regularity, but it was done for motives in particular circumstances. So I would sustain the objection to the flight plan. And then finally, there's agreement as to, for instance, the polygraph, the misdemeanor assault. But as to the phone call, I think that is a 703 issue. The proponent of the evidence may have the expert rely upon inadmissible evidence if they normally do so in forming their opinion, but the proponent may not otherwise disclose inadmissible evidence to the jury unless the benefit in understanding the opinion substantially outweighs the risk of unfair prejudice. And ultimately, for Ms. Pride to conclude that it was not a valid signature because someone told her later that they were coerced into saying it, in all candor, I don't think it's even truly expert testimony that somehow an expert is more qualified to understand that than a common lay juror. common ledger is not quite what I meant to say. That seems a little demeaning with our jury, but it would not be something that requires specialized expertise or knowledge to understand. And in the end, I would agree that essentially we would be using the expert as a conduit to hearsay to bring in evidence that would otherwise not come into the trial. And so at this point, I would sustain the objection to, unless circumstances change, having Ms. Pride testify as to the contents of what Samantha Lane told her. She can certainly testify as to the things that she did and the conclusions that she reached, but going to the actual content, I don't think that assists the jury in terms of understanding it. And it's really the ultimate unfair prejudice is that there's no way to cross-examine Samantha Lane to find out what the circumstances were, the details were. That's the reason the hearsay rule exists, so I will sustain that objection. Having said that, are the parties otherwise ready to proceed? Let me check with the plaintiff. Is the plaintiff otherwise ready to move to opening statements?
We are, Your Honor.
So is the defense ready to proceed?
Your Honor, before we proceed, may I ask for a clarification on the application for the restraining order? My video cut out when you were talking about that.
Oh, absolutely. My apologies. Go ahead.
Is your ruling at this time saying that you are admitting the restraining order, or is it pending the circumstances of the trial?
Actually, it's an important distinction, and it's a little way between both. What I'm saying at this point is I'm not precluding it in limine. Certainly the foundation for it will have to be set forth. And so I'm not ruling that it's admissible or admitted. I'm just denying the request to preclude it in advance of the trial, and we can address it at the time it's offered.
Yes, Your Honor. Thank you.
Excellent. All right, in that case, let me go ahead and turn it over to the attorneys, and I'll start with the plaintiff. When you're ready, for the plaintiff, you may give your opening statement.
Thank you, Your Honor. May it please the court. Your Honor, opposing counsel, members of the jury. A woman's greed is at the root of the case before you today. It was her greed that led her to take action early one morning. Her greed that deprived a son of his livelihood and a father of his life. That woman is Karen Beja. That father was Lou Donaldson, a self-made man who worked tirelessly to make enough money to fund his life's dream, Wild Wild Life, which was a rescue and sanctuary for big cats like lions, leopards, and tigers. Lou wanted this to be a family business, so he brought in his only son, Cam, to be his assistant, his right-hand man, and together, Lou and Cam ran Wild Wild Life for years. It even became a joke that Cam knew more about the business of Wild Wild Life than even Lou did. Enter Karen Beja, Lou's second wife, a woman 20 years younger than himself, who he met and married after Wild Wild Life was already a successful business. The evidence today will show extensive issues arose in Lou and Karen's marriage in the 12 years after they said, "I do." And as tensions between them escalated, Cam couldn't help but begin to take notice. And then one day, Karen's greed came to the surface and everything changed. You'll get to hear from Cam today, and you'll hear him tell you how he woke up early the morning of Sunday, August 19th, 2012, to the sound of the security alarm going off at the sanctuary office. And he'll tell you how he immediately jumped in his car and drove off to work to find out why. And that what he saw when he arrived was beyond concerning. The padlock securing the chain to the front gate to the sanctuary office had been cut. And the back gate to that same office was ruined. But before Cam could go inside with the police, out came Karen, smiling, carrying a lockbox. Karen told Cam that she had won. But at just what? Cam wouldn't learn until later. Cam will tell you he had no reason to suspect his father was dead or even missing that early morning. Why, he had just said goodnight to his father the Friday before and might have been planning on going over to his dad's house for family Sunday dinner. No one but Karen Beja yet knew that no one would see Lou Donaldson alive again. You'll get to hear from the defendant, Karen Beja, as well today. And she'll tell you a story of what she was doing there that early morning. Listen to that story carefully. And she'll also tell you about what happened after that tragic morning. How she immediately took over operations at Wild Wild Life, and how within the week, she fired Cam, Lou's assistant and right-hand man, the person who knew the most about running Wild Wild Life. Lou and Cam Donaldson never had family Sunday dinner again because Lou never came back home and he was never found. The only thing of his that was found was his van with his only pair of glasses that he needed to see and his keys on the front seat. A few weeks later, Karen produced what she'll claim to be Lou's last will and testament. A will different from any Cam had seen or known about before. This will and testament gave Karen Beja everything. And it left Cam, Lou's only child, with nothing. Karen Beja, a woman who satisfied her greed by getting rid of Lou and claiming his entire estate for herself. On the other hand, Cam Donaldson lost his father and was left with nothing. Nothing but questions. Questions about his father's disappearance and one woman's motives. Members of the jury, at the end of today's trial, it will be time for you to answer some of Cam's questions. No one can give Cam his father back, but you will have the power to restore to him a little of Lou's legacy, to give back a portion of what was taken from him out of greed. At the end of today's trial, we will ask that you find Karen Beja liable for Cam's losses, for Lou's disappearance, and indeed, his death. Thank you.
Nielsen, thank you very much. Ms. Farman, is the defense ready to give its opening statement?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. When people unexpectedly lose someone close to them, it's only natural to be angry, lash out, even to blame. In this case, Cam Donaldson blames his stepmother, Karen Beja, for his father's death. But Mr. Donaldson's blame is misplaced because Ms. Beja is not responsible for Lou Donaldson's disappearance. She did not cause his death. Mr. Donaldson decided to leave his wife, his child, his business, and move away. And we don't know where he went or why or when and how he died. And because Mr. Donaldson cannot prove that Ms. Beja caused his death, this is a case of misplaced blame. Members of the jury, my name is Hannah Parman, and along with my co-counsel, Alexandra Bartos O'Neill, I represent the defendant in this case, Karen Beja. Karen, could you turn your video on so that we could see you for a moment? In 2012, Ms. Beja's husband tragically disappeared And in 2017, she made the difficult decision to have him declared dead. In keeping with his wishes, she got the benefits of his life insurance policy and his assets, including the business that they own together, that she still runs today. Now, as Ms. Nielsen told you, Cam Donaldson has come here today to file a wrongful death suit against Ms. Baja, accusing her of causing his father's death. Now, everyone here agrees that Mr. Donaldson at this point is likely dead. But in order to win this case, Cam Donaldson has to prove that Ms. Baja caused his death, a burden he will attempt to meet by calling just 2 witnesses. And he will not be able to meet that burden. So after Mr. Donaldson has called his witnesses and presented his evidence, we'll call 2 witnesses of our own. The first will be Karen Baja. She'll introduce you to herself and tell you about her relationship with her husband. She'll tell you how they met hitchhiking, had a whirlwind romance, and decided to build a life together. She'll tell you that they got married and then over the course of years, built a life. Now, Ms. Baja's husband was an unusual, even eccentric man. He was a pilot and loved to fly. And the 2 of them shared one of his other unusual passions, the care and conservation of big cats like lions and tigers. And so by 2012, they were running this wildlife sanctuary called Wild Wildlife together, side by side. Now, Ms. Baja will tell you that like all marriages, theirs wasn't perfect. But you'll also hear that they were working on it. They were communicating and trying to get through this together. But on Friday, August 17th, 2012, Karen Baja was dealing with an emergency. You see, one of the tigers had given birth to some cubs and unfortunately had rejected them. So like any animal lover would, Ms. Baja stepped right in as mom to care for those cubs and try to give them a fighting chance. She'll tell you how in the middle of the night, they ran out of formula. And so she rushed to the grocery store in the early morning hours of August 18th in order to get supplies. Her car broke down, and knowing that her brother, a police officer in town, was on patrol that night, she called him for a ride so that she could get home to the animals quickly. Really, it was just another day in the life of a big cat sanctuary owner. The next day, August 18th, her husband had disappeared, and he was reported missing. And Ms. Baja will tell you how come Monday, she got up, got dressed, and went to the sanctuary to care for those animals, just like she knew her husband would have wanted. But she never stopped wondering when he was going to come back home. That waiting continued for 5 years. 5 years of hoping, of praying, of becoming less optimistic each time August rolled back around. And so finally, in 2017, she made the heart-wrenching decision to have him declared legally dead. As you'll see today, his will left her everything. And Ms. Baja will tell you that that's because he knew that she would keep the sanctuary going, that she would keep their shared dream alive. Now, unfortunately, one person was not happy with Lou Donaldson's wishes, his son, Cam Donaldson. And because his father isn't around to hear about how angry he is, Mr. Donaldson has brought his stepmother to court today. But as you'll see during this trial, the evidence just does not support Cam Donaldson's theory that Ms. Baja is responsible for the death of his father. And that will that Mr. Donaldson has an issue with, that brings us to our second witness, Chris Renard, an investigator for Summit Life, Mr. Donaldson's life insurance company. Mr. Renard is here today to tell you about an investigation that he did for Summit Life into Mr. Donaldson's disappearance and into his will. And Mr. Renard will tell you that based on her professional experience, she decided to pay out Ms. Baja's claim. Now, at the end of this trial, my co-counsel, Ms. Bartos O'Neill, will stand before you and she'll show you all the holes in the plaintiff's story. So many people were hurt by Lou Donaldson's disappearance, but just because someone is hurt doesn't make another person legally responsible. And so Ms. Bartos O'Neill will ask you to do what the evidence has shown and hold Ms. Baja not liable. Thank you.
Ms. Parman, thank you very much. All right, with that, then we'll go to the next stage of the trial, which is the presentation of the evidence, beginning with the plaintiff's case in chief. Is the plaintiff ready to call your first witness?
Thank you, Your Honor. Yes. We call Cam Donaldson to the stand.
All right, at this point, we'll presume that Mr. Donaldson, like all witnesses, has already been constructively sworn. So, Ms. Nielsen, I'll turn it over to you in terms of your inquiry. You may examine.
Thank you, Your Honor. Good evening. Please introduce yourself to the jury.
Good evening. My name is Cam Donaldson.
And where are you from, Cam?
I'm from here in Pioneer, Statesville.
Why are you here in court today?
Unfortunately, my dad is gone, so I'm bringing a claim against the estate, against Karen Baja.
I'd like to talk to you about your father. Is that all right?
Yes, that's okay.
What was your dad's name?
Lou Donaldson.
And what kind of relationship did you have with your father?
We had a close relationship ever since I was a kid. You know, we would throw the baseball around. We would go to a park. In college, you know, I could always rely on him. And then as I grew older, we actually got to work together.
When you were a child playing baseball in the park, what was your dad doing for work?
So he didn't have, you know, prestigious education background. And so, you know, he kind of had entrepreneur attitude. So he actually was a car salesman, but that was only a stepping stone for him. He actually saved up all that money to start his dream, which was the Big Cat Sanctuary, Wild Wildlife.
Tell us a little more about what is Wild Wildlife.
It's a big cat sanctuary, so it cares for, you know, tigers, lions. You know, some of them have been abused in the past or some are extinct. So, you know, we care for them. And it was something my father always had a passion for. He talked about it ever since I was little.
And were you involved with Wild Wildlife?
I was for about 20 years. And then Karen had fired me. But before that, I was pretty heavily involved with Wild Wildlife.
Can you describe more about what you were doing with Wild Wildlife, what your job was?
Yeah, I mean, you know, they would call me a mini-me. That's because, you know, I kind of did everything my father did. I would write the checks, order supplies. If anyone ever called off, I would also, you know, go in because I only lived a few minutes away. So I kind of did anything and everything that the sanctuary needed.
And when did you stop working that job?
It was a few days after my father had actually disappeared. Karen just out of the blue just fires me and kicks me out of my father's business.
And had you known if your father was unpleased with your work performance before that point?
No one ever.
Objection calls for speculation.
Your response.
Your Honor, this is not speculation. This is a rationally based perception based on what Cam Donaldson observed in his work that would have led him to expect whether or not there would be any disciplinary action.
Your Honor, may I be heard?
You may.
Your Honor, if counsel wishes to ask whether it seemed to him that anyone was displeased with his work, that would be different. But she asked whether his father was in fact displeased, and that is entirely speculative.
It's close, and generally the mindset of an individual and the thought process requires speculation. At this point, since we're talking about the emotional reaction, I'm going to find it's potentially a rationally based perception under 701. I'm going to overrule. You may finish your answer to the question.
Cam, did you know whether or not your father was in any way displeased with your work performance?
No, no one ever told me otherwise. My father was grooming me for the business, and he was kind of getting ready to teach me about more of the business side rather than like the day-to-day stuff.
You mentioned Karen. Who is she?
She is my father's wife. Technically, that makes her my stepmother.
And did you ever discuss his marriage with your father?
He did. My father had told me actually a few days.
Objection, hearsay.
Your response is to hearsay.
Your Honor, this is just the existing mental state of the declarant, his father discussing his marriage with his son.
Your Honor,
As an offer, what is it? Before we come back to exactly in a moment, first as an offer, what is it you anticipate the witness will say?
I will proffer that the witness would say that he and his father discussed his marriage and that his father intended to file for a divorce.
All right, let me come back, Mr. Parman, your response.
Your Honor, intent to file for divorce is not in fact a mental state, as Ms. Nielsen has said. That is a specific factual statement that is being offered for the truth of the matter asserted that Mr. Donaldson was seeking a divorce. If she asked whether Mr. Donaldson was happy in his marriage, that would be an actual existence of his mental state, but that was not the question, and this is in fact hearsay.
All right. Rule 803, I agree, it's hearsay, although Rule 803.3 also includes mental state, specifically including plan or intent. Since the statement of intent, as long as we keep it to that fact, I'll overrule. Find falls in the exception. You may ask the question.
Pam, did you ever discuss his marriage with your father?
Yeah, we did. About 2 weeks before he had disappeared, he had told me that he was going to file for divorce against Karen.
And did you ever witness any tensions between Lou and Karen firsthand?
Yeah, there was a fight that actually they had in the office, and I could hear them, back and forth. And my dad, he came out shaking, and he said that,
Objection, hearsay.
Your response.
Your Honor, if I may proffer?
Yes.
The witness is about to explain, and he's already said that his father came out of the office shaking. The witness is about to explain that his father was going to say that the police should look into Karen if anything were to happen to him as an excited utterance.
Your Honor, may I respond?
Go ahead. I'll let you respond. Yes.
Your Honor, I don't believe that this falls under the 803.2 excited utterance hearsay exception, which requires that the statement be made while under the stress of the excited situation, such as yelling ouch when a bus hits you. In this case, Mr. Donaldson was in the office having a fight, walked out of the office and over to his son's desk, which is not an excited utterance. Additionally, even if it was, based on what Ms. Nielsen has presented as an offer of proof, this would be substantially more prejudicial than probative under Rule 403, as Mr. Donaldson's belief about that is very, very prejudicial to the jury.
And then any last reply by the plaintiff, Ms. Nielsen?
Yes, Your Honor. We believe that this really does fall under the 803.2 excited utterance. The declarant, Leary Donaldson, was shaking, still excited from the fight that he had just walked out of.
Your Honor, may I respond?
At this point, actually, but the only thing that might happen is you might see defeat from the jaws of victory, so I'm going to have you hold off. At
yes,
this point,
Your Honor.
I don't think you have a sufficient factual basis for an excited utterance. There is an indication that he's under stress of some level of excitement. but I haven't, from the offer of proof, it doesn't appear to be that it's a statement relating to the cause of that or relating to the startling event or condition. It's projecting a future situation. And so with that foundation, I would sustain the objection at this point.
I will lay the foundation, Your Honor.
Right.
Cam, you overheard this fight and your father walked out of the office. How did he appear at that point?
I mean, he was visibly shaking. The two were screaming back and forth. I think she threatened him.
And what did you see of your father?
I mean, he just walked out. He looked kind of frightened.
And at that point, what did he do?
He said that if anything were to...
Objection, Your Honor. I would re-raise my objection as I don't believe proper foundation has been laid for the exception that counsel is attempting to offer this under. If I may, this exception requires a statement relating to a startling event or condition. Mr. Donaldson is not describing the fight in any way. He's giving an instruction to his son, and that does not fall under this exception.
At this point, I'm going to continue to sustain. I think we've absolutely established the prerequisite in terms of being under the stress of excitement, but I'm agreeing that the statement is not saying something like Karen just threatened me or something in terms of relating to what caused the stressor or the fight. It's talking about something in the future. And so I will sustain the objection as to hearsay and partially under a 403 issue, but I'll sustain the objection. I'll let Ms. Nielsen move on.
Thank you, Your Honor. Cam, we'll talk more about the circumstances surrounding your father's disappearance as we move on, but first I'd like to talk more about him. Apart from caring for cats, did your father have any hobbies?
Yes, he did. He loved to fly planes. And so he actually would buy a few. He'd take them out, fly them in the sky. He'd kind of travel all over the place. It was kind of a way that, he liked to clear his head.
And what kind of planes were these that he was flying?
I'm not an expert. I mean, they're not like fighter jets or anything. They're just like smaller, they look like cargo planes. I mean, you can maybe fit like another person in there. I mean, very, very small planes.
Did you ever go flying with your father?
I did, yeah. When I was a kid, it was the coolest thing in the world. He got to take me, and it was just a blast. I mean, at first it's a little scary, but then you kind of get into it.
Did your father ever take anything with him when he flew?
Yes. So he took his prescription eyeglasses. He was as blind as a bat without them. I mean, he could not see anything, and he'd bring his keys with him as well.
What could he see without his glasses?
He couldn't see much. I think he was nearsighted, so that means you really can't see that far. And so, I mean, as a kid, I'd mess around with him all the time, put stuff in front of him, but he always had them on.
And where did he fly?
He'd fly all over the place. I mean, there were times where he flew to Mexico, Canada. He'd fly to Central America. He'd give me postcards and, send me things like that.
And did he tell anyone when he was going to take a trip?
Yeah, he would usually inform me beforehand.
And were you aware of any planned trip the weekend he disappeared?
No. I remember it was, I believe it was like the 17th of August of 2012. It was a Friday, and he had told me that he would see me on Monday unless I stopped by the house on Sunday for dinner.
Is that the last time you saw your father alive?
Unfortunately, yeah, that's the last time I saw him alive.
Was there anything else out of the ordinary that happened the weekend your father disappeared?
I mean, yeah, to make things kind of crazier, the alarm went off that Sunday. So 2 days later it was like 6 a.m. or something. And so I ended up driving to the Big Cat Sanctuary because I only lived a few minutes away because I was worried that someone had broken in.
So what would you say you were the most concerned about at that point?
I mean, if someone broke in there or, took an animal or, let them loose, I mean, that'd be this bad for business.
What did you see when you arrived at the sanctuary office?
I was extremely worried. So there's like a padlock on the front door of the cat sanctuary that looked like it had been cut open, and then there's a back gate that's metal that I couldn't believe it. Someone had managed to break into.
Would you recognize a photo of the padlock if I showed it to you here in court today?
Yes, I would.
All right. Then I will direct opposing counsel's attention to the photograph previously stamped Bates Exhibit 004. It's located on page 28 of the case packet, directing the witness to the same. Cam, please let me know verbally when you have it up in front of you.
Yes, I have it pulled up in front of me.
Thank you. Cam, can you describe what you see in this photograph?
This is a photo of the padlock that's normally kept on the front gate. Usually whoever is, starting the night shift, they'll normally lock that up.
And is this photograph a fair and accurate representation of the lock as you found it on the morning of Sunday, August 19th, 2012?
It appears to be, yeah, it looks like the broken padlock.
Your Honor, plaintiff moves to admit into evidence plaintiff's exhibit number 1, a photo of the broken padlock.
Any objection to the exhibit?
No objection, Your Honor.
Exhibit 1 is admitted.
May I publish to the jury using share screen?
You may.
Cam, did you ever find out how that lock was broken?
When I first arrived, no. And then a few seconds later, I actually saw Karen it was some guy I had never seen before. I couldn't quite, make him out, but he had a pair of lock cutters.
And you mentioned the back gate had been broken into as well. Would you recognize a photo of that if I showed it to you today in court?
Yes, I would.
All right, directing opposing counsel's attention to the photo on case packet, page 29, previously Bates marked 005. And Cam, I'm directing you to the same. Do you have it in front of you?
Yes, I do.
Cam, can you describe to me what you see in this photo?
This is a photo of the back gate that morning. It's metal, and this looks like somehow someone broke into it. I couldn't tell you how.
Is this photograph a fair and accurate representation of the gate as you found it that morning?
It appears to be, yes.
Your Honor, plaintiff moves to admit into evidence plaintiff's exhibit number 2, a photo of the ruined back gate.
Any objection to exhibit 2?
No, Your Honor.
Exhibit 2 is admitted.
May I also publish this to the jury?
You may.
Thank you. Cam, did you find out what bent the back gate like this?
No, I don't know what could have done that.
Cam, did you go in to the sanctuary at that point?
No, so it's a little complicated. It's like I stepped in like the front gate, but I never stepped foot like into any of the offices or anything like that.
And were the police around?
Yeah, they had arrived a little before I did, I believe.
And what happened next?
So Karen had actually spoken with the police. It was like the strangest thing. She had told them that she was the owner of Wild Wildlife, but my father technically was. And I mean, he'd only been missing for 2 days. And she said that they could speak to her attorneys about if they had any further questions.
Did Karen say anything to you?
She did. I was extremely confused at first. She had the lockbox in her hand, and she had told me she won, and I didn't understand what she meant at the time.
She had a lockbox with her. Did you recognize that lockbox?
Yes. So that's the same lockbox that's in our office. There's only the one. We all share one, and it's in the drawer. So you need a key to get in. And normally my father's will is kept in there.
So you've mentioned now your father's will. Cam, what did you know about your father's will?
Yeah, in my dad's will, it was split into.
Objection, Your Honor, based on hearsay.
Any responses to hearsay?
Your Honor, this fits under the 803.3 exception to hearsay. The then existing mental state of actually Lou Donaldson regarding his will and his intent and plan for his estate.
Any response?
Your Honor, a will is not an intended exception of the 803.3 exception of then exempting mental, emotional, or physical condition. It is not related to those things based on Lou Donaldson. This out-of-court statement, this will, is the witness testifying to the contents of it when there is no will produced, no will that has been assigned a base number, and the jury will not be able to examine it. It's just impermissible hearsay and should not be admitted.
Your Honor, I have a further response if I may.
Oh, absolutely. Go ahead.
803.3 also includes a specific exception for wills. It says that unless it relates to the validity or terms of declarant's will, meaning that that is a specific part of the exception that is allowed for a belief of something that's remembered.
And since that's a different issue, any response, Ms. Parman, as to the additional language in 803 in terms of a will?
Your Honor, well, that is related to the declarant's will. In this case, I believe that exception is not including a statement of memory belief to include a fact remembered or believed. And I do not think that the portion of the will, the contents of the will that Mr. Donaldson is testifying to in this summarily way that he is doing it, summarizing the contents, should fit underneath that exception.
What I'm going to do at this point is I'm going to find, I think ultimately it may not even really be hearsay in that regard. It's an operative document. It's offered for its legal effect, not to show it's a true recitation of, or assertion of some historical fact, but more like a contract of saying this is the situation, has independent legal significance. But even if I didn't go that area, I think ultimately it is a statement in terms of the intent of the desire to have the property go. It's close enough under 803.3. I'm not totally sure, but we haven't addressed it in terms of best evidence issues, but the objection's hearsay. I'm going to overrule on that, allow you to ask him the question.
Cam, what did you know about your father's last will and testament?
In the will, it was split up into to 4 equal parts. So each person would get 25%. So 25% would go to me, 25 to my mother, 25 to Karen, and then the last 20 quarter is to go to Wild Wildlife.
And do you know how much your father's estate was worth?
It was Wild Wildlife was worth $5 million, and then the life insurance was another $5 million.
So under this 4 shares will, how much would Wild Wildlife have inherited from your father's estate?
They would only inherit from how much the company is worth, not the life insurance. So I think it's like 1.25 million, give or take.
And Cam, did you inherit your share?
No, I didn't inherit anything.
Objection, Your Honor, to the opposing counsel's mischaracterization of the evidence. As as an offer of proof, there is another active will of Mr. Donaldson's that is at issue in this trial, and her referring to this as can Donaldson share, when in fact the newly operative will does not include him, mischaracterizes the evidence in that way and the overridden will.
Any response?
Your Honor, I would ask what rule that objection falls under.
I think it's a common law objection in terms of mischaracterizing, misstating the objection. Arguably it's 611, but any response in terms of how it mischaracterizes?
Your Honor, this is this witness's perception of his father's will as he knew it. And we will continue on shortly into this other form of will.
At this point, since the witness had discussed a share that he would have received under the original will, I think it's a fair understanding that he's talking about whether he received that share. I'll allow it to be an issue of cross-examination, though, to clarify. So I'm going to overrule the objection. Let you ask the question.
Cam, did you inherit your share of your father's estate?
No, my under that will, my father wished for me to get a quarter of the estate, and I got nothing, not anything at all. And then on top of it, Karen fired me.
Why didn't you inherit anything?
So all of a sudden,
Objection, Your Honor, speculation. He doesn't know the mindset of his father in creating this will that doesn't give him anything.
I'll overrule at this point as long as it goes to a factual area. I agree if it's going to go into guessing what the father may have thought Lou Donaldson, I would sustain, but I think we're going to a different area, so I'll overrule. You can ask the question.
Cam, why didn't you inherit?
Mr. Donaldson, you can answer the question is what I should have said. Go ahead.
So she produced this will out of nowhere that just completely kicks me out and was not what I had seen before. And at the time, that's what she had meant when she had the lockbox and when she looked at me saying she won.
Tell me more about this new will. What did it say?
That Karen gets everything, and that I'm excluded. So is my mother. Wildlife. She is
Objection, Your Honor. Again, mischaracterizing the evidence. As an offer of proof, this will merely says, I leave everything to Karen Baja. It does not say anything about specifically excluding anyone, and Mr. Donaldson describing it in an inaccurate manner is prejudicial to the jury.
I'm going to overrule, allow that to be a subject for cross-examination, but I'll let the answer stand at this time, subject to the cross. You may finish the answer.
It excluded me. It excluded my mother, wildlife, and gave everything to Karen.
Was there anything else clearly different about this will that was carried out?
In the first will, there was nothing. I mean, it's like if I die language, but in the second one, it was strange. It said that if my father had died or disappeared. I'd never seen that language before.
Cam, how have you been coping with your father's death?
It was rough at first, the fact that he's missing, and it was rough. And then, the fact that I lost my job after, and that was kind of my dream with wildlife. It was my father's legacy, and the fact that I'm not able to participate in it, it's been rough.
Your Honor, no further questions at this time.
Any cross-examination?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. So, Mr. Donaldson, your father was a very unique man, wasn't he?
And somehow we're not hearing you. Also, they cut out, so at least I'm not.
Apologies, Your Honor. Can you hear me now?
No, it's still silent.
Mr. Donaldson, can you hear me?
I can hear you, yes.
Oh, okay. Everyone's hearing but me. Let me see if I can figure out why I'm the problem. Can you hear me?
I can, Your Honor.
All right. Let me see if I can figure out what's going on.
I muted and unmuted, Your Honor. Did that help? I'm also happy to drop and rejoin if that's needed. And you probably can't hear me.
Your Honor, opposing counsel's been talking. I don't know if you've been able
I'm
to.
still not hearing our witness.
Oh, he can't hear any of
Let me
us,
try
I think.
something else. Hold on just a moment.
Can you hear me now, Your Honor?
Your Honor, I believe you're muted.
Yes.
Thank you very much. I can hear you. I've had to switch to a different microphone speaker. The microphone is worse, but I can hear you all actually more clearly. So if you'll bear with me, and if you need me to repeat anything, let me know. But my apologies, Ms. Parman, go ahead.
Yes, Your Honor, and the audio is coming through okay.
Excellent.
Mr. Donaldson, your father was a very unique man, wasn't he?
Yes, he was.
In fact, some people might even call him eccentric.
You could call him that, sure.
He owned multiple big cats,
He did.
including lions and tigers, right?
Yes.
And you talked earlier about how he loved to fly planes,
Yes.
right? And you actually don't know how many planes he owned, isn't that correct?
No, I don't know exactly how many he owned.
That's right. And at the time that he disappeared, isn't it true that your dad didn't have a valid pilot's license?
Yeah, it was suspended.
So you talked earlier about overhearing a fight between your father and Miss Baja. You never witnessed any physical violence between your father and Miss Baja, did you?
No, nothing physical that I recognized.
Okay. And you never saw any evidence of an assault of any kind?
No, not physical.
Okay. And after that fight that you witnessed, they kept working together, right?
They did.
Quite closely, actually, right?
I mean, they had to work together, if that's what you mean.
Okay. And they kept living together, isn't that true?
I believe so.
Okay. Your dad didn't get a different apartment, right?
No,
And he didn't come to stay with you for any period of time, right?
that's correct.
Okay. And as far as you know, your father never actually filed for a divorce, did he?
I mean, he was going to, but he never actually filed the paperwork.
So that's a yes, he didn't actually file for divorce?
He didn't have the time to, no.
Okay. Now, you haven't seen your father in 8 years at this point, isn't that right?
Yes.
And you have no personal knowledge of how your father died, do you?
I'm confused, I'm sorry.
Sure. Personal knowledge, like you didn't witness anything with your own eyes or hear anything with your own ears.
No.
Okay. And you don't know where your father is, do you?
I mean, I assume Karen killed him. She produces this document out of nowhere. And
I didn't ask what you assumed. I asked you if you know where your father is, Mr. Donaldson.
he's dead.
Okay. And you don't know when that happened, do you? For a fact.
I don't know when.
Okay. So you talked quite a bit about an event at the sanctuary office early in the morning of the 19th, and I want to talk about that for a moment. So you say you saw Karen at the sanctuary office that morning, right?
I saw her at the office with the lockbox.
And that was the office of the sanctuary that she worked at, right?
That we all worked at, yes.
Okay. But she did work there, correct?
She's one of the employees.
And you say that the police came in after you.
Yes.
Okay. And you didn't bring a police report with you today, did you?
No,
You say the alarm went off, right?
it did.
You didn't bring any records from your alarm company.
They don't normally give out a record saying the alarm went off.
Okay. And at that point in time, isn't it true you didn't know your father was missing?
At that specific point, no. I was a little confused
Okay.
why he wasn't there.
Sure. You were confused why he wasn't there, but backing up on your way there, the alarm went off and you drove to the sanctuary, right?
Yes.
And you didn't call your father on the way to the sanctuary, did you?
No, I mean, I only live a few minutes away, so I didn't really have the time to. I was pretty worried about what was going on.
Okay, yeah, you didn't have the time at that point. So when you were at the sanctuary, you believed at that time that he was planning on leaving Miss Baja, right?
He had already planned that beforehand.
Okay, but you believe that was still his intention at that particular point in time, right?
Yes.
Okay. And so you saw Miss Baja walking out with a lockbox containing your father's will when you thought that she was going to leave him, and you didn't call your father?
Why would I call my father?
You didn't pick up the phone and say, hey, Dad, the woman you're about to divorce is walking out of the sanctuary with your will, right?
Why would I do that?
Okay. Is that a no to my question? You didn't call your father?
No, I don't know why I would.
Okay. So you believed your father's will was being stolen, but you didn't call him.
I mean, it was a different will, so I'm confused. I mean, it was different, so
Is it your testimony here today that you believe that the will in your lockbox wasn't your father's will?
it was a different version of it. That's not the will that I've ever seen before.
The will in the lockbox was not the version that you had seen. Is that what you're saying?
I'm assuming not, because she said in the version my father desired, I was to get a quarter, and all of a sudden the will she
Okay.
produced is I'm excluded and I'm his only son.
Okay, so let's keep talking about that will for a second. You would recognize the will that was presented that left everything to Miss Baja, right?
I would, yes.
All right, referring opposing counsel in the court to the document that has been marked with Bates number 2. Mr. Donaldson, do you have that exhibit in front of you? It's on page 53 of the packet.
Yeah, I have it pulled up, yes.
So this is your father's will that was presented in court, right?
This is the will that Karen produced.
So yes, this is.
The will that Karen produced.
Okay. Your Honor, defense offers in evidence Exhibit A. This document is Exhibit A.
Sorry, any objection to Exhibit A?
We have no objection to this, Your Honor.
Exhibit A is admitted.
Thank you, Your Honor. Ms. Bartos O'Neill, could you display this exhibit on the screen? All right, Mr. Donaldson, so you testified earlier that this will has language saying nothing goes to Cam, right?
It says Karen gets everything, so that excludes me.
Okay, but the will doesn't actually say anything about you, right?
That's the problem.
Okay, so that's a yes to my question.
I am not included in this will.
Thank you, Mr. Donaldson. All right, Ms. Bartos O'Neill, you can take that down. Now, Mr. Donaldson, your father's van was found at an airstrip, right?
It was.
And you previously said that you weren't familiar with that airstrip, right?
No, I'm not familiar with it.
Okay. And you don't have any idea how many planes your father owned at the time that he disappeared?
No, I have no idea.
In fact, isn't it true that no one knew how many planes your father owned because he didn't register them?
He didn't register some of them.
So is it true that no one knew how many planes he owned?
I mean, I don't know who knows if he has planes. I just know that there were some that he did not register.
Okay. And so isn't it possible that your father flew out of the country that weekend on a plane you didn't know about?
I mean, he normally tells me when he's going on a trip.
But it would be possible for him to go and for you to not know that a plane was missing, right?
It's possible, but unlikely.
Okay, thank you. So you don't like Miss Baja very much, do you, Mr. Donaldson?
No, she fired me.
But you didn't like her before that, right?
I mean, you could say that.
Okay. In fact, you kind of hate Miss Baja, right?
I mean, she's taken everything from me, yes.
In fact, you previously testified under oath that you hope she is attacked and eaten by one of her tigers. Isn't that true, Mr. Donaldson?
I did say that.
Yeah, okay. So isn't it true that your father's true love was working at the sanctuary?
I'm confused.
The thing your father loved most in the world, would you say that that was working at the sanctuary?
Oh, yes. Yeah, he did like
Yeah.
working at the sanctuary.
He really cared about providing for those cats, right?
He did.
And that's exactly what Miss Baja has been doing with her inheritance this whole time, right?
I have no idea. I don't work there, so I don't know what she's done.
Okay, but the sanctuary is still operating as far as you know, right?
To the best of my knowledge, it's still operating.
Okay. So, Mr. Donaldson, you last saw your father in 2012, isn't that correct?
That is correct.
And isn't it also true that you didn't bother to hire someone to look into his disappearance until 2017?
The insurance company told me that I had 5 years. So, I mean, I still did it within that time frame.
But you didn't hire someone to look into his disappearance in 2012, did you?
No, not right away.
Or in 2013?
No.
So you waited that entire 5 years to try to find out what happened to your dad, right?
I waited within the time frame, yes.
No further questions, Your Honor.
Thank you. Is there any redirect examination?
Yes, Your Honor. Brief redirect.
Go ahead.
Karen broke into the sanctuary office.
The guy next to her had the bolt cutters, and they were, walking right next to each other on the day that I had the alarm went off.
And Cam, how do you think your father died?
I think Karen killed him. I mean,
Objection, Your Honor. Speculation and invades the province of the jury.
Your response.
Your Honor, opposing counsel elicited this testimony earlier. I'm just bringing it back out.
Tell me a little
May I
bit more
respond?
before you do. Tell me how it would not be speculation for him to guess as to that fact.
It's also his rationally based perception based on the data he has available to himself. He knows that there was motive and opportunity for this to have happened, and that's his opinion on what he thinks happened.
Right. At this point, I don't think we have a sufficient foundation for the basis of the opinion, but in any event, it would be the type of opinion that wouldn't necessarily assist the jury, since they can look at the same evidence and reach the same conclusions. I'll sustain as to either being speculation or an improper lay opinion, but mostly speculation. Let's ask a different question.
Cam, do you miss your father?
I do, yes. I very much so.
Thank you. No further questions, Your Honor.
Thank you very much, Mr. Donaldson. I'll let you step down. Is the plaintiff ready to call your next witness?
Yes, Your Honor. At this time, the plaintiff calls Taylor Pride to the stand.
All right. Then Ms. Pride, will have you take the witness stand. You've already been constructively sworn, and so I won't do that again. I'll turn that over to Mr. Harwin. When you're ready, you may inquire.
Good evening. Would you please introduce yourself to the jury, Ms. Pride?
Good evening. My name is Taylor Pride.
And Ms. Pride, what do you do for work?
Well, I work as a private investigator at my own firm. It's called Pride Investigations Incorporated.
And how are you involved in today's case?
I was hired by Cam Donaldson in my capacity as an investigator to look into the circumstances surrounding his father's alleged disappearance and to analyze what's been called his last will and testament.
Now, we're going to go into that investigation in a minute, but before we do, I want to ask you a little bit about your background as an investigator. What were you doing before you became a private investigator?
Well, I started my career as a patrol officer with the Pioneer Police Department in 1998. And then from there, I was promoted to detective in 2000 and was a detective with the department for 16 years.
And in those 16 years, what sort of cases were you investigating as a detective?
I investigated every type of case, really. Economic crimes such as fraud and forgeries, violent crimes such as murder, everything in between.
And after you left the police department, what did you do next?
Once I left, that's when I started my own private investigation firm.
Now, as a private investigator, do you have any special certifications?
Yes, I've been certified by the American Board of Forensic Document Examiners since 2002.
And what does that certification mean?
So that means that I'm qualified to make determinations of forgery on documents and conducting handwriting analysis and comparisons.
Is that the kind of certification you need to maintain and update?
Yes, so I have to recertify that every 4 years, and it's currently up to date.
Now, have you ever testified in court before as an expert witness?
I have actually. I've testified 15 times, both in civil and in criminal cases, and for both sides.
At this time, the plaintiff moves to enter Ms. Pride as an expert witness in the field of investigations and forensic document analysis.
Is there any objection to voir dire?
Your Honor, we have no problem with tendering Ms. Pride as an expert in document examination and handwriting analysis. However, we do not believe she should be tendered as an expert for general investigations. And the reasoning behind that is we haven't heard any testimony about whether or not she has experience being an auditor of investigations. And we feel that at this point, for her to make any comment on the previous police investigation, or even suggest that Ms. Baja, for instance, should be charged in this particular investigation would be an inappropriate expert opinion for that limited purpose.
Any reply?
Yes, Your Honor. The opposing counsel's objection sounds ripe for a voir dire, but this witness has already testified that she had spent 16 years as a detective in the Pioneer County Sheriff's Department, and during that time investigating all sorts of types of cases that could include having done the sort of auditing of investigations that opposing counsel has the issue with here.
I'm going to first, she's accepted in the area that was uncontested in terms of the will issues. Given her background and experience in law enforcement, I think the rest would go to issues of either of weight or the scope of a permissible opinion. So I'll accept her as an expert in that field. If the opinions go outside the scope of her qualifications or expertise or proper opinion, Ms. Bartos-O'Neill, I'll have you make a contemporaneous objection. And other than that, I'll turn it back over to plaintiff's counsel. You may resume.
Ms. Pride, did you come to any opinions in today's case?
Yes, I did.
Now, before we get into what those opinions were, I want to ask you a few questions on how you reached those opinions. What sort of materials did you review?
Well, I had the opportunity to review Mr. Donaldson's alleged will, his driver's license signature, and the documents relied on by Mr. Donaldson's life insurance company, as well as the interviews with one of the declared witnesses on Mr. Donaldson's will.
Are those the standard types of materials that someone in private investigations would review?
Yes.
Were you able to apply those materials to the facts in today's case?
Yes, I was.
And were you able to apply reasonable methods and procedures in coming to your opinions in today's case?
Yes, I did.
And do you think that your opinions in today's case would help the jury better understand the evidence?
Yes, I believe it would.
Ms. Pride, what was your opinion about today's case?
Well, it's my opinion that the will produced by Karen Baja was not signed by Lou Donaldson and that the signature appearing on the will was forged.
And why do you think that the signature on that June 14th will was forged?
Well, I believe it was forged for 3 reasons. First, the circumstances around Mr. Donaldson's disappearance are incredibly suspicious. Second, the will itself and the manner and timing of when it was signed is also very suspicious. And third, a handwriting analysis of the signatures shows that it's unlikely that Mr. Donaldson himself signed that will.
Now, Ms. Pride, I want to break down each of those reasons for your opinion. starting with that first one about the suspicious circumstances around Mr. Donaldson's disappearance. When was the last time anyone saw Mr. Lou Donaldson?
Mr. Donaldson was last seen on August 17th, 2012.
And when did you begin your investigation into this case?
Well, Mr. Donaldson's son, Cam, hired me in July of 2017, so just under 4 years after his father disappeared.
Was there anyone else doing investigations into the disappearance of Lou Donaldson?
So the Pioneer County Sheriff's Office had been looking into Mr. Donaldson's disappearance since 2012. So technically it's still an active case in their office. But to date, they have not recovered Mr. Donaldson's body or made any investigation towards what Ms. Bozia might have been involved in with his disappearance.
Now, you had mentioned that the Sheriff County's department was investigating this. Did they uncover any traces of Lou Donaldson?
So they were able to find his van, and it was located on an airstrip.
Now, did Mr. Donaldson own any airplanes?
So it's my understanding that Mr. Donaldson owned an airplane and flew frequently as a hobby.
And would Mr. Donaldson's airplane that he owned be able to fly from Statesville to Costa Rica?
Maybe.
Objection, Your Honor. We believe this is an improper opinion by an expert. There hasn't been any testimony about her expertise in how these planes specifically work, nor have we heard any details about the specs of these planes.
Any response?
Yes, Your Honor. We heard from this expert that she was aware of Mr. Donaldson's aircraft. It has been stipulated by the parties the distance that it would take to fly from that airstrip to Costa Rica. And it's only basic math in order to determine the fuel economy of that type of aircraft based on that sort of distance that the parties had stipulated to prior in this case.
At this point, I'm going to sustain on a lack of foundation for her to have the qualifications to enter the particular opinion. So either have you laid the additional foundation or have you moved to a different area? You may resume.
Yes, Your Honor. Ms. Pride, were you aware of the type of aircraft that Mr. Donaldson flew?
Yes, I was. I was given a picture of it.
And were you able to determine how much fuel it would take to travel the distance from Statesville to Costa Rica?
Yeah, I looked at the plane and the plane specs and just did some math to figure out that what the fuel would be versus the distance.
And would Mr. Donaldson's plane be able to travel from Statesville to Costa Rica?
Maybe, but aside a plane of that size.
I apologize. My muting function was a little finicky. I re-raised my objection to lack of foundation and an improper opinion.
I'm actually going to sustain. I'm finding the witness doesn't have any special expertise or qualifications. She doesn't have education or background experience. She's done an investigation, but she's not an expert in the field. So I would sustain it under 702 and have you move to a different area.
Yes, Your Honor. Now, Ms. Pride, is there any indication at all that Mr. Lou Donaldson is in Costa Rica right now?
No, there's not any at all. I even sent an investigator down there to look for him and found nothing.
Do you believe that Mr. Donaldson is still alive?
I don't. There's no indication that he is still alive. And in fact, his bank accounts have not been touched since his disappearance.
Now, I want to turn to that second reason for your opinion on believing that the will produced by Ms. Beja was forged. And that was the circumstances around the signing of that will. If I were to show you a copy of that will, would you recognize it?
Yes, I would.
I'm directing opposing counsel's attention to what has been previously entered as Defendant's Exhibit A. Permission to publish to the jury, Your Honor?
You may show Exhibit A to the jury, yes.
Now, Ms. Pride, what day was this will supposedly signed?
So the date on the will is June 14th, 2012.
And is there anything significant about the day, June 14th, 2012?
Yes, That would have been 2 days after Mr. Donaldson filed for a restraining order against Ms. Baja.
Objection, Your Honor, mischaracterization of the evidence under Evidence Rule 403. I believe Ms. Pride just referred this to a restraining order. The document actually isn't a restraining order. It's a request for a temporary one.
Any response?
No, Your Honor. I will re-ask the question and ask that the violating testimony be stricken and allow the witness to recharacterize how that request for a restraining order was submitted to the court.
Jury will then disregard the last answer then, and I'll let you ask and rephrase the question.
Yes, Your Honor. Now, Ms. Pride, why was the date June 14th, 2012 so significant to your investigation when you looked at this will?
The date was significant because 2 days before, there had been a request for a restraining order by Mr. Donaldson against Ms. Baja.
So why then was it strange to you that Mr. Donaldson changed his will after that?
Well, it's hard to believe that 2 days after requesting a restraining order against Ms. Baja, he would then alter his will to leave his entire fortune to her at the expense of his only child, Cam.
Now, Ms. Pride, do you frequently look at wills during your investigations?
Yes, I do. It happens really frequently.
And was there anything strange about the language that was used in this particular will?
Yeah, well, unlike the other wills that I've reviewed, this one specifically said, quote, in the event of death or disappearance.
Ms. Pride, were you able to speak to any of these witnesses that are listed on the will?
Yes, I was.
And which one was that?
That was Miss Samantha Lane.
Now, without going into what your conversation was with Miss Lane, did that conversation impact your opinion that you came to in this case?
Yes, it did.
Finally, Ms. Pride, I would like to turn to that third reason that you gave the jury today on why you believe that Mr. Donaldson's signature on that June 14th will was forged. And you said that that was the handwriting analysis that you had performed. How do you go about performing a handwriting analysis?
So a handwriting analysis is a 3-step process. First, you get the known samples from the author, a journal, a notebook, a list, something they've written. Second, you analyze those known samples to look for handwriting characteristics in the shapes, curves, and angles, stroke and direction. And then third, you compare those characteristics to the writing in question.
So for this case, were you able to obtain originals of Lou Donaldson's signature?
Yes, I was. I was able to get his signature on his driver's license, his signature on the request for a restraining order paperwork, and a note that he had written to his son, Cam.
You had mentioned that request for a restraining order. If I were to show you a copy of that request for a restraining order, would you recognize it?
Yes, I would.
I'm directing opposing counsel and the witness to the document that has previously been Bates stamped 0014. I believe you would be able to find that in the case packet on page 55.
Yes.
Ms. Pride, what have I just shown you?
So this is the request for a restraining order paperwork.
How do you recognize it?
Well, I've reviewed it before in my investigation, and it was part of the materials I reviewed.
And does it look substantially the same as the last time you reviewed it?
Yeah, completely the same.
At this time, the plaintiff moves to enter the request for restraining order as plaintiff's exhibit number 3.
Any objection to Exhibit 3?
Objection.
Exhibit 3 is admitted.
Permission to publish to the jury?
You may.
Now, Ms. Pride, what was distinctive about Mr. Donaldson's signature on this original document?
So the way that Mr. Donaldson would write his L's with a smaller top loop, so the top of the letter was smaller than the bottom. He also used an extra loop in the O in Lou. And when writing the U in his first name, he used a small tail at the end of the letter. And then finally, that second O in Donaldson, it's what we call a lazy letter because it's not clearly written.
And how is this different than the way his signature was supposed to be in this will that was produced that was dated June 14th?
Yeah, so they are different. In Mr. Donaldson's known samples, he would rarely lift the pen when he was signing. And then on the will, it looks as though the signer had two distinct pen strokes. The lazy second O is used throughout this version of the signature, and there are quivering indications that the person signing was doing this very slowly.
So what did that lead you to believe about this signature that was on the will?
So it led me to believe that this signature on the June 14th was not Lou Donaldson's.
Mrs. Pride, are you aware of any other wills that Mr. Donaldson might have had?
Yes, he had another valid will.
Now, if that will had been produced at the time of his disappearance, how much money would Karen have received?
So with that will, it would have been about 1.25 million.
And with this June 14th will that Karen produced instead, how much money did she receive from Lou's estate?
$5 million.
Thank you, Ms. Pride. No further questions at this time.
Is there any cross-examination?
Yes, Your Honor. Good evening, Ms. Pride. Can you hear me all right?
Yes, I can.
So I want to start by talking about the circumstances you investigated into Mr. Lou Donaldson's disappearance. Now, you were hired about 5 or so years after he had disappeared, right?
Just about 4.
That was in 2017, correct? July of 2017?
Yes.
Okay. And that was just about a month before he was declared dead, correct?
Yes.
Now, you would agree with me that when somebody goes missing, like Mr. Donaldson did, it's the police's job to investigate that disappearance.
I guess.
And they would do that on behalf of the public, right?
Yes.
And you do know that they did investigate Mr. Donaldson's disappearance.
They started to.
Okay. And that investigation happened about 8 years ago in 2012, right?
Correct.
So you know that Mr. Donaldson was a wealthy man, right?
He was.
He had a family.
Yep.
And he had a business in the state of Statesville, right?
Correct.
Now, you would expect that the police would do an investigation into what might have happened to him, right?
Yes.
Now, you did mention on direct examination that part of the police's investigation was looking at a van of Mr. Donaldson's, right?
Yes.
As far as you're aware of, the police didn't find any blood in that van, right?
Not that I'm aware of.
Or any DNA evidence suggesting a sign of a struggle or violence, right?
Not that I'm aware of.
Well, the police didn't stop there in their investigation. You're aware that they also interviewed individuals, correct?
Yes.
They interviewed Ms. Baja, for instance.
Correct.
You're also aware that the police didn't file any charges in relation to Mr. Donaldson's disappearance.
I am.
And nor did they arrest anybody.
No, they didn't.
Ms. Baja wasn't charged or arrested, right?
Correct.
Now, I want to go back to your investigation. Now, you looked at some of the same information that the police had, right?
I did.
And unlike the police, you came to court here today on behalf of Cam Donaldson, right?
Cam Donaldson hired me, yes.
That's right. And you're being paid for your testimony, correct?
As part of my investigation.
And so in fairness to you in regards to this investigation, you came and did your own investigation years after Mr. Donaldson had disappeared, right?
I did.
And after all of those years, you didn't find any DNA evidence, right?
I did not.
You didn't find any new eyewitnesses either in your investigation.
Eyewitnesses to his death?
Or the disappearance, in relation to the disappearance.
That's correct.
Now, I want to talk to you about how you spend your time analyzing the documents. Now, you were asked to look at a will that was presented by Ms. Baja, right?
I was.
Okay. And just to be clear, you didn't witness this will getting created, right?
That's right.
And you don't know any of the individuals who signed that will personally either.
Not personally, but I have spoken with one of the witnesses.
Okay. Well, you don't know the reason why this will was created?
I don't.
Now, you would agree with me that there's nothing wrong with Mr. Donaldson giving his money to his wife, right?
Nothing wrong. It's just suspiciously written.
And you're not aware of any other obligations that Mr. Donaldson had to give his money to somebody else, right?
I know there was another will that split the money differently among his family, the wildlife sanctuary, and Miss Baja.
Well, Ms. Pride, it is entirely within Mr. Donaldson's right to change his will if he wanted to.
Correct.
It's entirely within his right to do with his money as he pleases, right?
Correct.
So I want to talk to you about your analysis into that signature. Now, you looked at several of Mr. Donaldson's signature samples in order to make your comparison, right?
Yes, I did.
Okay. And you would agree with me that having more information is better than less information?
I guess.
And having more recent samples of Mr. Donaldson is better than having older ones, right?
I mean, signatures only change so much.
But you would agree with me that having a more recent signature as part of your comparison would be helpful, right?
I suppose.
Now, as you mentioned, no one's signature is ever exactly the same, right?
Correct.
And that makes sense because if someone were to write their signature very quickly, it would probably look different, right?
That's right.
If they were to write it with a different pen than they're used to, that would also cause some differences.
Minor ones.
Now, that's why it's better for you to have as many samples of Mr. Donaldson's signature for your comparison, right?
Correct.
So you mentioned on direct examination that you reviewed the documents that the insurance investigator, Chris Renard, had reviewed as well, right?
Yes, I did.
You mentioned that you had Mr. Donaldson's signature on the request for the temporary restraining order.
Yep.
You mentioned that you had his driver's license signature.
Yep.
You also mentioned that you had his signature on a note that he wrote to his son.
Correct.
And with Chris Renard's documents, you also had access to his signature on some insurance paperwork, right?
Yes.
Now, in your direct examination, when you talked about analyzing that signature, you only compared it to the one on the request for the restraining order, right?
I'm so sorry. I think I cut out. Could you repeat the question?
Absolutely. In your direct examination, when you were analyzing those two signatures, you only analyzed it with the one from the request for the restraining order, right?
I looked at all the signatures in front of me.
Okay, but in your report specifically, you only mentioned differences between the driver's license signature, the application, and the application for the restraining order signature, right?
Right.
Now, you also, that note from Mr. Donaldson sent to his son, that was written in May of 2012, right?
It was.
And you didn't produce that document or bring it with you here today.
No, I didn't.
And that document was written just a couple of months before Mr. Donaldson disappeared, right?
Correct.
Thank you, Ms. Pride. We have no further questions at this time.
Was there any redirect?
Yes, Your Honor, briefly. Ms. Pride, would you ever let your compensation impact the results of your investigation?
No, not at all.
Do you need to know why someone had created a document in order to do a forensic document analysis of it?
No, I don't. I'm just looking at the documents in front of me.
And would having known that reason change your opinion at all in this case?
No, it would not have.
Thank you, Ms. Pride. No further questions, Your Honor.
All right. Then Ms. Pride, thank you very much. You're free to step down. Does the plaintiff have any additional witnesses?
No, Your Honor. At this time, the plaintiff rests.
Right. And does the defense have any issues it would like to raise at this time?
Your Honor, at this point, the defense would move for judgment as a matter of law under Rule 50.
All right. Any additional argument in support of your motion?
Yes, Your Honor. Your Honor, the elements that the plaintiff has to prove in this case are that Mr. Donaldson is dead, that this was caused by an intentional or reckless act of Ms. Baja, that Ms. Donaldson has injuries resulting from his father's death, and that the defendant's conduct was the cause of plaintiff's injuries. Now, we agree that Mr. Donaldson is dead, but there has not been sufficient evidence presented at this point for any reasonable jury to find on the remaining three elements. There has been no mention of any intentional or reckless act by Ms. Baja besides the supposed break into her own office that was discussed, which in no way is linked to any actual death of any kind. As plaintiff's own expert agreed with, Mr. Donaldson had every right to do with his money as he wanted. So any injuries that Cam Donaldson, is feeling as a result of the will's distribution have nothing to do with Ms. Baja's intentional conduct. Without causation, the plaintiff just can't meet their burden at this point. So we would move for judgment as a matter of law under Federal Rule of Civil Procedure 50.
Any response?
Yes, Your Honor. When viewing the facts in the light most favorable to the non-moving party, in this case, the plaintiff, a reasonable juror could find that the plaintiff has met all four of its elements today by a preponderance of the evidence. As opposing counsel already conceded, the first element is met because all the parties agree that Lou Donaldson has in fact died. As for the second element on the causation of Karen Baja, a reasonable juror could make the connection between Ms. Baja's motive and that Mr. Donaldson was ready to file for divorce, the threats that she had made against him already, and not to mention the temporary restraining order that was entered in the examination of Taylor Pride, which describes Ms. Baja's plan and motive into taking the life of Lou Donaldson. Therefore, a reasonable juror could find that we have met that element as well. As to the last two elements on the damages to Cam Donaldson, he described his grief after the death of his father. He described having lost his job, and that lost income is directly related to Karen firing him. Therefore, we have met our burden in today's case for at least one reasonable juror, and this motion should be denied.
And since it's the defense motion, any final reply?
Your Honor, just to say that it would be a travesty of justice to allow any fight between a married couple to be the basis for a wrongful death suit with no other evidence of wrongdoing by one of the parties. And so we stand by our motion.
All right. I think the parties have done an excellent job of honing in the issues. Certainly, I agree that there's no dispute as to the first element that Lou Donaldson is dead. I think it's fairly clear that there's sufficient circumstantial and direct evidence that Cam Donaldson would have suffered injuries or damage or losses as a result of that death if the other elements are established and proven. The primary issue then is, was there sufficient evidence upon which a jury could find, viewing the evidence in the light most favorable to the non-moving party and granting them all inferences, including any circumstantial evidence that the cause of death was the intentional or reckless conduct of the defendant in this case. If that is established, and I think there's otherwise sufficient evidence that the defendant's conduct would have been the cause of the injuries or death. I think at this point, given that low standard, and the fact that I have to consider circumstantial evidence and disregard contrary evidence, that I'm going to deny the motion for directed verdict at this time, allow the case to proceed to the defense. And other than that, let me just check back with both parties. Anything before we take a short recess at this point?
Just a request for a short recess, Your Honor.
And how are we on time at this point? I think we're ahead of schedule, but I'll check with our timekeepers. Where do we stand on the time?
Yes, Your Honor, the plaintiff side has used 37 minutes of their 70 minutes, and the defense has used 24 minutes and 30 seconds of their allotted time.
All right, and we're 2 minutes in roughly at this point. I'm sorry, 2 minutes, 2 hours in at this point. It's almost 8 o'clock. It's a little bit different. How long were the parties looking for in terms of our midpoint break? We could do a 10-minute break if you think that's sufficient so we can get back and get wrapped up, or did you need more than that?
10 would be more than enough for the defense, Your Honor.
Same for the plaintiff, Your Honor.
All right, and then for our scoring panelists and observers as well, and our participants, we'll go ahead and take a 10-minute recess. I show it's almost 5 till, so we'll come back no later than 5 after and resume with the test. All right, we'll be in recess for about 10 minutes. All right, it looks like we have all of our competitors ready to go. Are all of you ready to resume?
Yes,
Yes.
Your Honor.
Let me check with our scoring panelists, make sure they're back as well. Are both of our scoring panelists ready to resume as well?
Yes, Your Honor.
Yes, Your Honor.
Thank you, gentlemen, both. I had neglected to do one thing, and our panelists may have figured it out as well already. I hadn't gotten our team codes. I want to make sure my understanding was we were scoring plaintiff Blanca Peak and defense Castle Peak. Is that correct?
That is correct.
Thank you both. So for our scoring panelists, I know on that second page, there's the team codes, questions 3 and 4. We've got Blanca Peak and Castle Peak. But other than that, at this point, the plaintiff has rested its case in chief. We're ready to proceed to any defense presentation of the evidence. Defense ready to call its first witness.
Yes, Your Honor. The defense calls Karen Baja.
All right, Ms. Baj, if I can have you step up as a witness. Oops, we had you for a moment. There we go. That's fine. You've been previously
Yes, Your Honor.
sworn, so I'm just simply going to turn this over to counsel. When you're ready, Ms. Bartolomeo, you may inquire.
Yes, Your Honor. Please introduce yourself to the court and spell your last name.
Hi, I'm Karen Baja. My last name is spelled B-A-S-I-A.
Now, Ms. Baja, you've been sitting throughout trial today and listening to everything that's been going on. So I'm going to ask you up front. Did you have anything to do with your husband's disappearance?
No, of course not.
Did you forge his signature on his last will and testament?
No.
I want to go back and I want to talk to you a little bit about your background. Where did you grow up?
I grew up here in Pioneer. I've been here since I was a little kitten. My parents were working class, so we grew up on the poorer side of town, but nothing too bad.
What do you do for a living?
I am the owner and CEO of Wild Wildlife. I'm also what I like to call a cativist. I help to push through legislation that helps to protect large cats.
I'm referring the court to documents labeled Bates number ending in 0018 and 0019. This would be on page 57 and 58 of the case packet. Ms. Baja, do you have those two documents in front of you?
Yes, I do.
What are they?
They're some of the cats we have here at the sanctuary. They're so cute, aren't they?
Your Honor, the defense offers exhibit B and C into evidence.
And B and C are, which of the 3 pages I think that are on there? It was 57, 58?
57 and 58, they are photos of 2 cats.
Thank you. Any objection to exhibits B and C?
Yes, Your Honor. Plaintiff would object as to the relevance of these photos of the cats.
Your Honor, may I respond?
You may.
Your Honor, the bar for relevance is very low. We're attempting to have these exhibits be entered to show Ms. Baja's devotion to her career, to the cat sanctuary that both she and Mr. Donaldson ran together as part of their dream. Now, we believe that this evidence will go to refute a plaintiff's counsel's contention that she was greedy and just after Mr. Donaldson's money.
And let me ask, how do these pictures do that other than showing pictures of 2 adorable tigers and 2 adorable cubs?
Your Honor, these are just photos that of some of the cats at her sanctuary that she took care of with Mr. Donaldson.
All right, any response?
Yes, Your Honor. That does not make a fact of consequence more or less likely in this case. And furthermore, opposing counsel just told you that she wanted to use this to demonstrate Ms. Baja's devotion, which raises a 404 character objection as well.
It is a little bit of a close call, I agree. Under Rule 401, we still have to have evidence that makes a material fact or fact at issue more likely to be true or less likely to be true. I don't think there's any risk of unfair prejudice. And so I think although the probative values are very low, it does help place in context the facts that we're hearing in terms of the type of animals that were there. Since there's really no prejudice, I'm going to overrule at this point. I don't think it goes to a character issue and admit exhibits B and C.
Yes, Your Honor. Ms. Baja, could you tell us what drew you to taking care of big cats?
Yes, I think they're just the perfect animals. I mean, they're so peaceful, and you really have to have a temperament, a gentle temperament in order to work with these animals. And I feel like I have that. I'm able to connect with them on a spiritual level.
How did you meet your husband?
That's actually kind of a tale. I was hitchhiking in Pioneer, and he picked me up. He was my real Prince Charming. And, you know, people have given me slack for the age difference, but that really doesn't give me pause.
Why did you feel that you and your husband connected so well?
I think we had the same temperament and same values. We both value the life of all living creatures, and we think that, you know, everything deserves to live a peaceful and happy life, and no one should take advantage of that or benefit over someone else's life.
Objection, Your Honor. This is too far into character evidence. The defendant is describing her temperament directly into a propensity inference on how she acted on the occasion of Lou Donaldson's disappearance. And I ask that that offending testimony be stricken.
Your Honor, may
Any
I
response? You may.
Yes, Your Honor. Ms. Baja's testimony about the relationship with her husband is not to show any propensity that she was gentle with him or nonviolent with him on the day of his disappearance. What we're simply establishing here was that Ms. Baja and Mr. Donaldson had a good relationship, and this is specifically to refute plaintiff's statements that their relationship was on the rocks and that she would have motivation to kill him as a result of a divorce or anything like that.
Any response given that offer?
Yes, Your Honor. We are not disputing Ms. Baja's ability to describe the relationship that she had with her husband, but going as far as to say that it was a shared temperament for gentleness is directly into a character evidence of her as a defendant, which leads the jury to an improper propensity inference.
It gets close to that, I agree. And I think under different circumstances, I might sustain. But at this point, since the plaintiff has raised the issue in terms of the fighting and the disagreement between them, characterizing the relationship, I think, has been made relevant by that. I think the probative value isn't substantially outweighed by the risk of unfair prejudice. So I'm going to overrule at that point. Let you proceed.
Yes, Your Honor. Ms. Baja, how long were you and your husband married?
We were married almost 12 years. We got married back in 2001. And so by the time he disappeared, it had been about 12 years.
Did the two of you live together?
Yes, we did, all the way through until he disappeared.
Were you also in business together?
Yes, we both worked at the Wildlife Sanctuary.
I want to go into more detail about your marriage. Did the two of you ever get into any arguments?
Yes, of course. I mean, what marriage doesn't have arguments? It wasn't perfect, but we were soulmates. And for the most part, we were in love and happy.
And we've heard some testimony today about a request for a temporary restraining order. Do you know anything about that?
I mean, Lou was impulsive. He would get an idea into his head and go with it. And he regretted it as soon as it happened. And we moved on and we were happy.
404.
Any response? Any response to the 404 objection?
Your Honor, I'm not exactly sure what plaintiff's counsel is suggesting as showing action in conformity therewith. I believe Ms. Baja's testimony is limited to the reactions of the request for the temporary restraining order.
And I'll let you clarify in your reply.
Yes, Your Honor. The defendant just described Mr. Lou Donaldson as impulsive, and I believe she was trying to describe him as someone who would take impulsive actions and act in conformity with that character, such as flying away to Costa Rica, as we expect the defendant's theory of the case to be.
Given that it's more of a 404A issue in terms of impulsivity as opposed to prior other acts, any response?
Your Honor, it was not our intention with this testimony to suggest that Mr. Donaldson was an impulsive man, and because of that, that's the reason why he decided to take a trip to fly off. We were simply using this testimony to explain the circumstances of the request for the temporary restraining order, and we're happy with a limiting instruction to the jury to indicate that.
I think if we were trying to go to that area, plaintiff is raising in terms of establishing impulsivity for flying to Costa Rica, I would agree that that would be character evidence. At this point, given that there's a proper use for it in terms of basically explaining the particular filing in this case that I've otherwise permitted, I'm going to overrule. We would normally instruct the jury with a limiting instruction. I'll presume that that would be the case, but I'll let you proceed.
Ms. Baja, could you describe what was going on in your relationship in relation to the request for the temporary restraining order?
We were just having an argument and he decided to file the restraining order. After that point, you know, he felt bad and he tried to make it up to me.
What about the statements in that request for the restraining order? Do you know about those?
I don't know about those.
Now, after that request for the restraining order was filed, did the two of you still continue to live together?
Yes, we continue to live together.
And as far as you're aware of, did Mr. Donaldson file for divorce?
As far as I'm aware of, no, he didn't.
Ms. Baja, I now want to talk to you about Mr. Donaldson's disappearance. When did he disappear?
He disappeared on August 18th, 2012.
And when he went missing, what was your first thought?
My first thought is that he had gotten into his plane and gone away. He often did that. He would get up and decide that he wanted to go to some other country or some other place for business or for other reasons. And so I figured that's what had happened.
Objection, Your Honor. That goes directly to the impulsive 404 character evidence discussion we just concluded.
Any response?
Your Honor, I apologize. I can tailor my question a little bit more narrowly so as to not elicit that type of response from Ms. Baja.
I'll sustain the objection, direct the jury to disregard the last answer, and let you ask your next question.
Ms. Baja, did your husband own planes?
Yes, he did.
Did he know how to fly them?
Yes, he did.
Are you aware of about how many planes he owned?
No, I knew that it was a lot, but I didn't know how many.
And if your husband decided to take a trip, would he tell you where he was going?
Not always.
Now, when your husband disappeared, did you look for him?
Yes, of course. I wanted to find him.
And when you went to look for him, did you discover anything?
Well, about a week later, after searching everywhere, we did eventually find his van in one of the hangars.
What was in his van?
There was some keys and his glasses.
Now, I am now directing the court to a document with Bates number ending in 0012. That's on page 50 of the problem. Ms. Baja, do you have that in front of you?
Yes, I do.
And could you describe briefly what that document is?
That's a picture of Lou's van.
The defense offers Exhibit D into evidence.
Is there any objection to Exhibit D?
No objection, Your Honor.
Exhibit D is admitted.
And permission to publish Exhibit D by sharing the screen.
You may.
Ms. Parman, would you please share your screen? Now, Ms. Baja, you said that you found this van at a hangar. What kind of hangar was this?
It was a flight hangar. It was one of the places that Lou kept his planes.
Ms. Baja, you can stop, or excuse me, Ms. Parman, you can stop the screen share. Now, Ms. Baja, as far as you're aware of, did the police investigate your husband's disappearance?
Yes, as far as I'm aware, they thoroughly investigated.
And Ms. Baja, I want to talk to you about August 18th now. What were you doing between the time period of August 17th and August 18th?
Well, I was working at the sanctuary. Unfortunately, we had some cubs that had been abandoned by their mother, and so I was having to take care of them. When that happens, I mean, they're newborns, and so you have to attend to their every need. So I was with them throughout that entire time.
Did you at any point leave the tiger cubs that you were taking care of?
Yes, in the middle of the night, I did end up leaving in order to get some formula and milk for them. We had run out.
Around what time was that?
That was around 3 a.m.
Did you return to the Cubs?
Yes, I did eventually return to the Cubs.
How did you get back?
Well, unfortunately, I was so scattered that night. It was in the middle of the night that I left in my old car and it broke down. And so I left my phone back at the sanctuary. So really embarrassingly, I had to flag someone down, use their phone in order to call my brother to come pick me up and take me back to the sanctuary so I could get back to the cats as quickly as possible.
And at that point in time, was your husband with you?
No, he wasn't.
Did you kill your husband during that time period?
No.
And as far as you're aware of, did your brother have anything to do with your husband's disappearance?
No, not that I'm aware of.
I want to talk to you about the following day, August 19th, 2012. You've heard testimony today about a break-in into the sanctuary. Do you know anything about that?
No, I don't know anything about that.
Baja, do you have keys to the sanctuary?
Yes, of course. I'm the owner.
Do you have access to the rooms or facilities at the sanctuary?
Yes, of course.
Now, Ms. Baja, do you recall the police being at the sanctuary at any point in time on August 19th?
No, I don't know anything about that.
And did you ever take your husband's will and get rid of it?
No.
Now, Ms. Baja, when was your husband declared dead?
He wasn't declared dead until 2017.
From the time of when your husband disappeared in 2012 until 2017, what were those 5 years like for you?
They were really hard. I mean, I was having to take care of the sanctuary all by myself, and that's a lot of work. It takes a lot of time and money and effort. And so those 5 years were really hard, and I was missing him the entire time.
What was your expectation after Mr. Donaldson disappeared?
I was expecting that he would leave me the ability to keep taking care of the sanctuary. That was his life's mission and goal, his love. And so I knew that he wanted me to make sure that it kept running and that the cats were well cared for.
Why did you declare him dead in 2017?
That was really hard. I mean, I had been hoping and wishing that he would come back, but finally, after 5 years, I had to give into the fact that my Prince Charming wasn't coming home.
Did you file for insurance benefits?
Yes, I did.
And did you submit his will to probate court after you declared him dead?
Yes, I did.
Now, Ms. Baja, would you recognize that will that you submitted to probate court if we were to go over that today?
Yes, I would.
I'm referring the court to what has been previously entered as Exhibit A, a document labeled the Last Will and Testament. Ms. Parman, would you please share your screen with that document? Ms. Baja, can you see the screen?
Yes, I can.
Were you there when this will was signed?
Yes, I was.
Did you see Mr. Donaldson sign this will?
Yes, I did.
And did you see this other witness listed here sign this will?
Yes, Ms. Lane, I saw her sign.
Ms. Parman, you can stop the screen share. Thank you. Now, that will gives you everything of Mr. Donaldson's property. What was your understanding of what you were supposed to do with that?
My understanding was that I was supposed to take care of the sanctuary. I mean, it costs a lot, and he knew that. And so he wanted to make sure that me and the cats were taken care of and the sanctuary was able to stay open and keep protecting those cats.
Are you still working at the sanctuary to this day?
Yes, I am.
Did you move, Ms. Baja?
No, I'm still where I've always been living.
And did you remarry?
No, I didn't.
Thank you, Ms. Baja. We have no further questions at this time.
Is there any cross-examination?
Yes, Your Honor. Ms. Beja, first, I would like to explore a little bit about your relationship with your late husband, Lou Donaldson. On direct examination, you had mentioned that you met Lou while you were hitchhiking.
Yes, I did.
And he had picked you up off the side of the road?
Yes, he found me and we lived happily ever after.
He was just a stranger to you, though, at that point.
I mean, yes, but I could tell that he was really nice.
And the two of you went to a motel that night?
Yes, we did.
And you spent the night together that night?
I guess so.
And you thought that it was love at first sight?
It was.
And then later, the two of you were married?
Yes, we got married.
You considered him your soulmate?
Yes, I do.
And you thought everything was perfect?
I didn't think everything was perfect, but I thought it was a very good marriage.
It's testimony today that you didn't think everything was perfect?
I thought we had our ups and downs, but it was a very good marriage.
Miss Beja, eventually things stopped being so good, didn't they?
I mean, there were times that were worse and there were times that were better.
Your husband told you that he wanted to get a divorce.
I don't know about that.
Is your memory exhausted on this issue?
I mean, I don't remember him telling me that he wanted to get a divorce.
So it's your testimony today that Lou never asked you for a divorce?
Yes.
I'm directing opposing counsel's attention to the deposition of Karen Beja. Ms. Beja, you gave a deposition in preparation for today's case, didn't you?
I did.
Your attorney was there?
Yes.
An attorney for Cam Donaldson was there?
Yes.
During that deposition, you were asked to be truthful.
Yes.
And you were?
Yes.
And you're aware that up until 24 hours before this trial began, you had an opportunity to change anything that you thought was wrong in that deposition?
Yes.
Now, I'd like to direct opposing counsel and Ms. Beja, if you have a copy of the case packet in front of you, this is on page 44 of your deposition, or 44 of the case packet entirely. And we're looking at about 4 lines down. Now, if you could look at that and read along, I'll speak out loud and you just read along, all right? Mr. Donaldson asked you for a divorce. Is that correct? Answer, yes, he did. Did I read that correctly, Ms. Beja?
Yes, you did.
Now, also, Mr. Donaldson had filed a requested a restraining order against you.
Yes, he did, but the court didn't grant it.
And you also thought that Mr. Donaldson had been cheating on you.
I did think that he had a mistress in Costa Rica where he flew off to.
Now, you weren't Mr. Donaldson's first wife, correct?
No, he had another wife before me.
And it was with that first wife that he had his son, Cam?
Yes.
Now, you didn't like Cam very much, did you?
No, he was kind of a catty boy.
You didn't trust Cam?
I mean, I wouldn't say I don't know him about that.
It's your testimony. You don't know whether or not you trust Cam?
I didn't particularly trust him.
And it's because you didn't trust Cam that you went to the office the night after Lou disappeared. Isn't that right?
I don't know about that.
It's your testimony that you don't know if that was the reason why you went to the office?
I don't know that was my reason.
Ms. Beja, let's look back at that deposition again. Now I am directing opposing counsel's attention to, this would be, excuse me. I'll move on, excuse me. Ms. Beja, let's talk about the night of August 18th. You said that a tiger had given birth to some cubs.
Yes, they had. Yeah.
And because of that, you needed to go out to get some supplies.
Yes, I needed to get some formula and some milk in order to make sure that they were fed.
But you didn't bring your cell phone with you when you went out.
No, it was in the middle of the night. I was tired and I forgot it.
And that became a problem when your car broke down.
Yes, I had to find someone in order to figure out a ride.
Now, you mentioned this was the middle of the night. This was actually at 3 in the morning, correct?
Yes, it was.
But you were able to flag down someone else,
Yes, luckily there was someone driving by.
and they let you use their phone.
They were very nice. They did.
And you didn't use that phone to call someone else at the tiger sanctuary.
No, it was the middle of the night. They were all sleeping. They work really hard during the day.
You didn't use that phone to call your husband, Lou.
No, I mean, I don't know. He doesn't always remember his phone either, so I didn't know he would pick up.
You used that phone to call your brother.
Yes, he's a police officer, and I knew he was awake, and I knew that he would be able to come and get me quickly.
A police officer with the Pioneer Sheriff County Police Department, correct?
Yes, that's where he works.
The same police department that investigated Lou's disappearance?
I guess so.
The same police department that you described on direct as doing a thorough job into investigating that disappearance?
Yes, they did.
Now, Ms. Beja, this was the morning of August 18th, wasn't it?
Yes, early in the morning.
And you are the person who reported Lou missing, aren't you?
Yes, when I realized he wasn't around there, actually, I don't know who reported him missing, but I do know that I didn't know where he was at that point.
Now, Ms. Beja, I'd like to turn to what happened after Lou was gone. Since Lou's disappearance, you've become a rather wealthy woman.
I guess so. I have enough money in order to make sure the sanctuary is running.
And as a part of the will you produced, you inherited all of Mr. Donaldson's estate.
Yes, he wanted to make sure that there was enough money to take care of the sanctuary.
So in that will, Mr. Donaldson didn't leave anything to the sanctuary, did he?
He didn't leave anything to the sanctuary directly. He wanted to make sure he knew that I knew how to run it. I had been running it with him for years, and he knew that I knew what was in the best
To my
interest.
question. He didn't leave anything to the sanctuary?
No, he left it to me in order to run the sanctuary.
Ms. Beja, he didn't leave anything to Cam, his son.
Not that no, he didn't.
So you inherited the full $5 million estate of Lou Donaldson after he disappeared.
Yes, I did.
Now, on direct, you also mentioned a life insurance policy, didn't you?
Yes.
That was also worth $5 million?
Yes.
So in total, after your husband disappeared, you inherited $10 million.
Yes, I did.
Thank you, Ms. Beja. No further questions.
Is there any redirect?
No, Your Honor, we ask that Ms. Baja be excused.
All right, thank you very much, ma'am. You're free to step down.
Thank you.
Is the defense ready to call your next witness?
Yes, Your Honor. Defense calls Chris Renard to the stand.
All right, Ms. Renard, since you've previously been sworn, I won't swear you back in. Instead, I'll turn this over to counsel. When you're ready, you may inquire.
Thank you. Good evening, Ms. Renard. Please state your name, spelling your last for the court reporter.
Good evening. My name is Chris Renard, last name spelled Renard.
How did you get involved with this case, Ms. Renard?
Well, I work for Summit Life Insurance Company, and I was just investigating the claim by Karen Beja that her husband, Lou Donaldson, had died, and she wanted the insurance payout.
So you investigated the validity of that claim?
Correct.
Did you investigate the will as well?
I did, yes.
Did you form conclusions about those topics?
I did.
Before we get into those conclusions, let's talk a bit about your background. You said you work for Summit. What do you do for them?
Well, specifically, I'm an investigator and a forensic document examiner.
What responsibilities are involved with that role?
A lot of different things, but I mostly just take a case from the bottom and investigate everything to the top. So assess the losses, review the insurance policy, I speak with the police, I collect and preserve evidence, and do independent investigations and interviews even.
How long have you been doing that work for Summit?
I began in 2000, so for about 20 years now.
What did you do before working for Summit?
I was a forensic document examiner for the Statesville Bureau of Investigation for a crime lab. I did that for about 23 years.
Was it 3 years, Bernard?
I'm sorry?
Was it 3 years, Ms. Renard?
Yes.
And did that involve similar work to what you do now for Summit?
Yeah, very similar. Just analyzing the handwriting, signatures of documents, looking into fraudulent claims and fabrication.
And do you have any formal education that lets you do this line of work?
Well, I don't know if it's formal per se, but I mean, I got my Bachelor of Arts in Criminology and I attended a police academy.
And do you have any specific certifications?
Do I have any, could you repeat the question?
Do you have any specific certifications?
Yeah, I mean, I'm qualified to testify in both federal and state court, so I would consider that a certification. I've done that for 25 times before.
Your Honor, at this point, defense would offer Ms. Renard as an expert in insurance investigation and document examination.
Any objection of voir dire?
No objection, Your Honor.
All right, shall be so accepted. May I offer opinion testimony pursuant to Rule 702. You may proceed.
Thank you, Your Honor. So, Ms. Renard, let's talk about your investigation, what your investigations generally, my apologies. What do those generally involve?
Yeah, like I mentioned earlier, just really investigating the claims. So I'll speak to all the friends, the family, the police officers, and, review the relevant documents, check into bank records, things like that.
Why do you speak to law enforcement?
Well, to see if, first of all, any charges were filed against the claimant, see if they're pursuing anything against them, any foul play, of course, and, just analyze the evidence if they're willing.
Why would it matter whether charges have been filed against the claimant?
Well, if it's a fraudulent claim, foul play would probably be involved with that, so.
And what steps did you take in this particular case until Lou Donaldson, the claim on his policy?
Well, a first of the few steps that I took were just, like I said earlier, first talk to the family, then talk to the police.
So let's start with your conversations with law enforcement in this case. Were you able to determine, based on your investigation, if any charges were filed?
No, they weren't.
Did you determine if anyone was ever arrested?
No, they weren't.
Did you determine if Ms. Baja specifically was charged?
Yeah, she was not charged.
Did you determine if there was any physical evidence of a murder?
As far as I'm aware, there's no evidence uncovered that Mr. Donaldson was murdered, no.
Did you determine if there was any physical evidence of foul play at all?
No.
Did you learn if anybody that knew Mr. Donaldson had an alibi?
Yeah, they had alibis like Miss Baja, she had an alibi, she was getting milk.
So moving to your conversations with friends and family, what did you learn from those conversations?
I mean, it became pretty clear that Mr. Donaldson just disappeared, unfortunately.
So let's move to the next part of your investigation, into Mr. Donaldson's will. What documents did you review as part of your investigation into the will?
Quite a few. I obviously looked at the will that was brought forward by Miss Baja, and then we had a signature of Mr. Donaldson at our office for his insurance policy. In addition, we saw his driver's license and that signature, and we went to the DMV, got that signature, so quite a few samples.
Would you recognize a copy of Mr. Donaldson's will if you saw it today?
Yes, of course.
Permission to publish to the jury the document that has previously been admitted as Exhibit A?
You may.
Ms. Bartos O'Neill, will you display that document? Ms. Renard, is this Mr. Donaldson's will?
Oh, it is, yes.
Did anything about the contents of this will strike you as odd?
Well, it did seem strange that disappear was used as a triggering word for the estate to be administered.
And would that language invalidate the will in any way?
Oh, no. People can write their wills however they want. I mean, who am I to judge?
Ms. Bartos O'Neill, you can stop sharing that. So why did you look at the driver's license and life insurance signatures?
I just kind of wanted to establish a baseline of Mr. Donaldson's handwriting and specifically his signature and create like a fingerprint.
And did you prepare any documents in your comparison of Mr. Donaldson's signatures?
Did I compare any documents?
My apologies, prepare any documents.
Prepare any documents. Specifically, I mean, I compiled a report of my findings, if that's what you're asking.
Did you prepare a document that showed the signature comparisons?
Yes, that was part of my report, yeah.
Would you recognize that portion of your report if you saw it here today?
Yes, I would.
Referring opposing counsel, the court, and the witness to the document with a Bates number ending in 007, which can be found on page 40 of the problem. Ms. Renard, do you have this in front of you?
Yes, I do.
What is this document?
This is the comparison I did of the signatures.
Is it a fair and accurate copy of the document you prepared?
It is, yes.
Defense moves to admit this in evidence as, I apologize, I have slightly lost track, but I believe this is Exhibit D.
I'm sorry, which number was this?
I believe this is Exhibit D, Your Honor. Exhibit E, my apologies. E is an elephant. Yeah.
That's what I was thinking. All right. Any objection to Exhibit E?
Oh, Your Honor, this is fine.
Exhibit E is admitted.
Thank you, Your Honor. Permission to publish to the jury?
You may.
Ms. Bartos O'Neill, could you display this document on your screen? So what does this document show us, Ms. Renard?
It shows the signatures that I compared in the course of my investigation.
And based on this document and these signatures, what did you ultimately determine about Mr. Donaldson's will?
I mean, I cannot say anything that it was forged, but it seemed to me like it was his signature.
Thank you, Ms. Renard. Ms. Bartos O'Neill, you can take that document down. And actually, Ms. Bartos O'Neill, if you could display the will, Exhibit A again. We'll give her a technical moment. Ms. Renard, there are two other signatures on this will. Did you review anything related to those?
I did, yes. I looked into the witnesses.
Why do people witness a will, Ms. Renard?
I mean, to verify the legitimacy of the signature in the estate planning document itself.
And the second signature, Ms. Baja, did you have any conversations with her?
Yes, I did.
And what conclusions did you draw based on those conversations?
That she had witnessed the will.
And this first witness, Samantha Lane, did you have a conversation with her?
I did.
What conclusions did you draw based on that conversation?
I concluded that she likely witnessed the will as well.
Ms. Bartos O'Neill, you can stop sharing. Ms. Renard, based on your years of professional experience in this area, what did you ultimately recommend that Summit Life do about Ms. Baja's claim?
Yeah, well, I mean, there is obviously sufficient similarities and the differences were inconclusive at best. So my professional recommendation was to pay the proceeds of the policy to Ms. Baja.
Your Honor, no further questions.
Is there any cross-examination?
Yes, Your Honor.
Please go ahead.
You work for Summit Life Insurance, Ms. Renard.
Yes, I do.
And you've been working there for 20 years?
Yes.
And you've testified in court 25 times? And 24 of those times were on behalf of your employer, Summit Life Insurance Company.
Yes, yes, that's my primary job.
And you reviewed hundreds of wills in the course of your employment.
Correct.
So you know when a will looks to be standard.
Yes, I do.
And you would also be able to recognize if a will was a little unusual.
In certain aspects, yeah.
And you would admit that Lou Donaldson's will was a little unusual.
I'm sorry, which part of the will are you referring to?
Well, generally, Lou Donaldson's will was a little unusual.
I wouldn't agree with that, no.
There was a phrase in Lou Donaldson's will, if I should die or disappear, yes?
Yes.
Is it standard in a will to include the phrase, if I should die or disappear?
No, the disappearance, like I testified, that is not usual.
So in that way, at the very least, Lou Donaldson's will was unusual.
That's correct.
But in all the wills you've ever reviewed, that is the only one to include that phrase.
Yes, that's true.
Lou Donaldson was declared legally dead on August 18th, 2017.
Yes.
And Karen Beja had him declared legally dead on that day, yes. She filed her claim for the life insurance policy on that same day.
Yes, she did. That's something that a lot of people do, especially after that long of a period of time.
But it can be a cause for concern when someone does that.
Potentially, and depends on the circumstances of the case, of course.
And do you believe Lou Donaldson is dead?
Yes, I do, and it was legally declared.
And you examined Lou Donaldson's signatures.
That's correct.
And you can't confirm to a reasonable degree of scientific certainty that that signature on the will was genuinely Lou Donaldson's.
Right. I couldn't say with genuine certainty, but I mean, there didn't seem to be any issues or foul play with it.
Your results were inconclusive.
I mean, I concluded ultimately that the insurance should be paid out, yes.
But it's possible the signature was a forgery.
Yes, that's, of course, always a possibility, unfortunately.
Let's discuss the witnesses to the will. There were 2 witnesses to this will.
Yes, that's correct.
And it's usually disfavored to have a beneficiary act as a witness to a will.
Yes, that is generally disfavored.
And Karen Beja was one of the witnesses to this will.
Yes, along with Lou, with Miss Lane.
But Karen Beja was a beneficiary to this will.
Yes, she was.
In fact, Karen Beja was the sole beneficiary to this will.
That's correct.
The other witness was allegedly Ms. Samantha Lane.
Yes.
And you spoke to Ms. Samantha Lane.
I did speak with her, yes.
And then you received a letter claiming to be from Ms. Samantha Lane.
I did receive a letter from her, or claiming to be her.
And that letter claimed that...
Objection, Your Honor, hearsay.
Your response.
First, Your Honor, they opened the door. Second, we are not offering this for the truth of the matter asserted, but rather to call into question this expert's credibility and the extent to which they performed their investigation in this case.
Is there a particular rule you're relying upon?
We're just not offering it for the truth of the matter asserted.
All right.
Your
response.
Honor, may I be heard?
Yes.
Yes, Your Honor. Your Honor, first, the plaintiff, in fact, opened the door with their conversations surrounding Samantha Lane and their experts' conversations with her. Ms. Renard had another conversation, and that is why she had spoken. Additionally, experts may rely on hearsay, but cannot testify, be used as a conduit for hearsay. Ms. Renard has already testified to her conclusions based on her conversations with Ms. Lane. If opposing counsel wants to ask about the existence of a letter, that would be reasonable, but to use this as a way for opposing counsel to read hearsay onto the record without inquiring about the conclusions that Ms. Renard drew based on that would be impermissible.
Any final reply by the plaintiff?
We're not reading anything onto the record here, Your Honor. I am asking about this letter, but I am not reading it.
This is an area, actually, I think I referenced earlier. Rule 703 precludes the proponent of opinion testimony of bringing in inadmissible evidence, except for certain exceptions. But the opponent of the opinion is able to bring in occasionally inadmissible evidence to attack the basis and grounds and reasons thereof. In other words, the fact that this witness didn't consider those facts or reach the conclusion despite learning those facts, it's admissible. So we're close in the area, but I'm going to overrule the objection because it's the opponent of the this particular witness in that regard asking the question. I will allow you to go into areas that would otherwise be inadmissible. You may proceed.
Thank you. You received this letter from Samantha Lane.
Yes, who supposedly was Miss Samantha Lane. Mm-hmm.
And this letter claimed that Samantha Lane had never seen Lou Donaldson sign the will.
Yes, that's what they claimed, and I tried to follow up with that, and I never got a hold of her, unfortunately.
This letter also claimed that that Samantha Lane had been coerced into signing the will.
Right, and like I said, I just couldn't verify that.
Right. And you, as you said, you investigated this letter.
I did.
And you began your investigation by calling Ms. Beja and asking her about it.
That's pretty common to speak with the claimant.
You talked to Ms. Beja first in investigating this letter from Samantha Lane.
Yes, I spoke with her first.
And Ms. Beja confirmed to you that indeed both she and Samantha Lane had witnessed the signing of this will.
Yes. Mm-hmm.
And after that, then you tried to contact Samantha Lane.
Yes, I tried to contact Samantha Lane, yeah.
And you were then unable to contact her again.
Yeah, I couldn't contact her, so I just relied on what she had originally told me.
And it was as if Ms. Lane had disappeared.
I mean, I just couldn't talk to her on the phone. I don't really know where she is.
You submitted your report to your employer on September 26, 2017.
Yes.
And Lou Donaldson had already been dead or declared legally dead for only 40 calendar days at that point.
That sounds correct.
And 29 of those, including both the day of the legal declaration and the day you submitted your report, 29 business days.
Okay, yes.
So in all this time, you talked to Samantha Lane first, called Karen Beja, tried to contact Samantha Lane again, but were unable to find her in that short amount of time.
Unfortunately, yes.
And yet, in the end, you did not contest payment of the $5 million life insurance policy to Karen Beja.
Right. I mean, no one wants to give out $5 million, but I just had no reason to believe that it was any foul play.
And contesting any payment to Karen Beja of the $5 million life insurance policy would have meant that Summit Life Insurance Company would go into litigation.
Potentially. I'm not sure.
And litigation would be costly to your employer.
To my employer? Yeah, maybe. I'm not sure. That's a kind of above my head.
Thank you. No further questions, Your Honor.
Was there any redirect?
Yes, Your Honor.
Go ahead.
Ms. Renard, let's start with your whole investigation. Do Do you feel that you did a thorough investigation into this case?
Yes, I would say so. I'm really just an objective party trying to do my job.
And you said that you don't generally like to just give out $5 million. Does that impact how thorough your investigation would be?
I mean, I would probably was more thorough. I mean, I wouldn't say I'm less thorough normally, but you know, sometimes if the pressure of $5 million is on your back from your boss, you know, motivates me to get the gears going.
So on the contents of the will, you said that the disappeared language is unusual, but was it cause for concern in this particular will?
It wasn't to me. No, everything that I had investigated showed there was no signs of foul play.
Based on your investigations into the will altogether, do you believe it's valid?
I do. That's why I recommended that the payout be made.
Let's talk about your interaction with Samantha Lane. Why did you choose to disregard that note?
Like I said, I couldn't get a hold of her, and I've spoken to her on the phone, which I thought, you know, was more valuable to me than a unverified note. I have no idea who sent that, so I went with what she told me. Sorry.
Were you ever able to determine whether Samantha Lane in fact sent that note?
I was not.
No further questions, Your Honor.
Thank you, Ms. Renard. Thank you very much. You may step down. Does the defense have any additional witnesses?
Apologies, Your Honor, I was premature. And no, at this point, the defense rests.
All right. And let me check our time for our witnesses. Where do we stand in terms of remaining time for both sides?
The plaintiffs have used 53 minutes and 30 seconds, and defense has used 52 minutes and 21 seconds.
And how much does that leave for both sides then?
Less than 20 minutes.
All right. Let's go ahead then and shift to closing arguments. Is the plaintiff ready for closing argument?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor. My only ask before I do my closing argument, I'm not sure if plaintiff feels the same, that if we could ask the bailiff to give us some sort of countdown during our closing argument so we can keep track of time.
And how much of an advance note? Are we asking for to be notified when you have a certain amount of time left or something different?
Preferably counting down from about 7 minutes or so.
Right. When you say countdown, that would suggest that she keeps giving you updated times like 10, 9, 8, 7. Are you saying every minute, every half minute? What are you looking for?
10 minutes, 9 minutes, 8 minutes, 7 minutes. That works perfectly fine.
That'll work. Anything then for the plaintiff before we begin closings that you wanted to address?
Yes, Your Honor. The plaintiff would like to reserve 2 minutes of rebuttal time.
All right. With that, then, that's all acceptable. We'll go ahead and go to closing arguments, beginning with the plaintiff's closing argument. And when you're ready, you may proceed.
May it please the court. Opposing counsel, members of the jury. When you think about all of the evidence that you've heard in today's case, the witnesses that you've listened to, and the people that were closest to Lou in his life, I want you to realize that there's only one reason that we're all here. Greed. Greed that cost a son his father, his inheritance, his job, and any sense of peace or closure over the last 8 years. All because of one woman, the defendant in this case, Karen Beja. One woman who just happened to be picked up hitchhiking by Lou Donaldson all those years ago. Now, she told you in today's case, members of the jury, that she fell in love right away. But whether that was with Lou or with his money, that's for you to decide. Now, we know that they were married, but then after a little more than 10 years, Lou had finally had enough of Karen. After her death threats, after he asked her for a divorce, after he tried to get help from a court that wasn't there for him, Karen realized that her golden goose was about to get away from her. That all of those years that she had been living the life of luxury with Lou was about to go away. And that's when she realized she had to do something. Now, it's important, members of the jury, to realize that this isn't a criminal case that we've brought here today. As the plaintiff, we did not need to prove to you beyond a reasonable doubt that Karen did everything that she did to Lou. But because we are the plaintiffs, we do have a burden. That burden is called the preponderance of the evidence, which just means more likely than not. You can think of it like a glass of water. If that glass of water is half full and just one more drop is in there, that means that the plaintiff must prevail. That means that after everything that you've heard today, you think it's more likely than not that Karen had something to do with why Lou's not here anymore. You must find for Cam. Now, if you think about everything that Karen has been so cavalier to lie about, lie to the police, lie on documents, and lie to you, members of the jury, from that stand today, you'll understand why we probably won't know everything that happened that night Lou disappeared. But after closing arguments are done, you're going to get some instructions from the judge. And part of those instructions are going to be that you're allowed to use your common sense in coming to the facts of today's case. And using those to fill the gaps of what Karen won't tell you will only lead you to one conclusion. So let's talk about what we do know. We know that the last time anyone saw Lou alive was August 17th, 2012. You heard that from his son, Cam, that the last words he ever got to speak to his father was, "Good night, Dad. See you next week. If I don't see you on Sunday for family dinner first." But he didn't see him that Sunday. It's important, members of the jury, to think about how the only person that you heard testify that knew Lou, that couldn't tell you the last time she saw him alive, was the defendant in this case. She did tell us a story, though. And let's think about that story she told us. That on August 18th at around 3 a.m., this just being a few hours after Cam had left the Tiger Sanctuary and had seen his dad for the last time, she told you that she needed to go to the store. But she also told you she didn't bring her cell phone. So there's no way to verify if that's actually where she went that night. She also told you that her car broke down, so she needed to call her brother, not her husband, not anyone else at the Tiger Sanctuary, but her brother, a police officer with the Pioneer County Sheriff's Department. Now, I can't think of a better person to call when you needed to get rid of some evidence than a police officer with the very same police department that would be investigating Lou's disappearance. And some investigation they've had, you heard today that that's still an open case despite it being 8 years since anyone has last seen Lou. Now, we know no one saw Lou on the 18th of August. We know that no one saw him on the 19th either. But what happened on the 19th of August, 2012 is the final piece of the entire puzzle. You heard what Cam told you, that on that night, an alarm went off and he went to the Tiger Sanctuary and he saw a lock broken, a gate damaged, and the defendant standing there with a lockbox. In that lockbox was where Lou Donaldson kept his will. Now, you've heard about two different wills in today's case. One that Lou had created in order to give his son an inheritance, in order to make sure that there was money for the Tiger Sanctuary after he was gone, and still gave Karen some money too. But you also heard about the will that Karen produced after Lou disappeared. And it is that will that is the most important piece of evidence that you will take back into that jury room with you. This is the best demonstration of how far Karen was willing to go to get what she thought she deserved, Lou's money. It's so important, members of the jury, that you heard from two experts today about this will. Now, both of them told you something very similar, that it's hard to say that this could possibly be Lou's signature on the will. But Miss Taylor Pride went a little further. She told you that there was no way that the signature on that will could possibly be Lou's. This, members of the jury, is Defendant's Exhibit A. And if you look at that will, I'll walk through exactly why it was so important in today's case. First, look at the date. This will was supposed to have been signed by Lou Donaldson on June 14th, 2012. Well, why was that such a special date? Miss Pride told you. And you can see it right here on this request for a temporary restraining order. The date was just 2 days earlier. Now, the defense spent some time saying Lou could do whatever he wants with his will. But ask yourselves, members of the jury, is it more likely than not, after Lou filed a restraining order, after being threatened for his life by Miss Beja, that he would then go and completely change his will, writing out his life's work and his son? But that wasn't the only problem that you heard about with this will. You heard from Taylor Pride how these signatures don't match up. And you can put these two exhibits right next to each other, side by side, members of the jury, and see that they're supposed to take place 2 days apart and look nothing alike. A time frame that doesn't make sense, signatures that don't match. Lou never signed this will. But you don't even have to just take my word for it. You don't have to take just Taylor Pride's word for it, because the defendants brought an expert too. And they showed you this exhibit, and you can see this. This is the defendant's exhibit number E. And look, right down here in the notes, I cannot say if the signature on this will is genuine. Members of the jury, that should stop you right there. Miss Beja saw her golden ticket leaving, and she did everything she could to make sure that it wasn't getting out without giving her some of that money. So she changed and forged Lou's signature, changed his will, and then took his life, robbing the plaintiff, in this case, Cam Donaldson, of not just his father, not just his birthright, his sense of closure, his relationship that he could have had, and his own dreams, his own work at the sanctuary. That is why we brought this case today. And because we're the plaintiffs, we had 4 things that we needed to prove to you. That Lou Donaldson's dead, that the reason he's dead is because of Karen, either recklessly or intentionally, that Lou's death has caused his son Cam damages, and that Karen is the cause of those damages. Now, we can move right past the first one. Both parties have conceded today that Lou has passed away. The harder question for you to answer will be, why? But members of the jury, to draw that line between Karen's lies, between Karen's fraud, and between Karen's threats against Lou's life, it's not hard to put it together. You even heard her take the stand today, and she couldn't even tell you the truth about the problems she had in her marriage. She lied about Lou asking for a divorce. Why wouldn't she have been lying about everything else that she told you? Now, as to the third element, Cam has clearly suffered because of the loss of his father.
5 minutes, counsel.
Not only the relationship that he had with him, not only the inheritance that he was robbed from, but this was where he had been working with his dad for 20 years, where he was posed to be running it after he was gone. That loss of income for Cam and that loss of his dream, that has to be compensated for. Which leads us right to our fourth element, how Karen's responsible for this. You heard that she was the reason that he got fired. You heard that she was the person who faked the new will. That draws a bright line right to Karen on how she hurt Cam. Now, there is not an amount of money in this world that could possibly ever make Cam whole again. Nothing's going to bring Lou back. But sometimes when you have a woman like the defendant who's so consumed with greed, the only thing you can do is take the fight to their pocketbooks. So when you go back to deliberate today, we're going to ask you to consider three things. First, that Lou Donaldson, in his valid will, would have left 1/4 of his estate to Cam Donaldson, his son. That comes out to $1.25 million. Second, for pain and suffering, for the loss of a father and any future relationship that he could have had with his son, Cam is asking for an additional $500,000. And third, because Cam had lost his dream and his work and his livelihood because Karen ruthlessly kicked him out of the sanctuary the second Lou was out of the picture, for future earnings, we're asking for another $500,000. Altogether, that comes up to $2.25 million that we're asking for you today. Less than 1/4 of the $10 million that Karen made by getting rid of Lou. But her greed won't let her let go of that. So in a second, you're about to hear her attorneys come up here and muddy the waters and try and say Cam doesn't deserve a penny. But they don't have that power, members of the jury. You have that power. You can give Cam justice. You can give him closure. Find the defendant liable and don't let Karen win. Thank you.
Thank you. When the defense is ready, you may proceed with your closing argument.
Yes, Your Honor. Can you hear me clearly?
Yes.
In August of 2012, Mr. Donaldson unexpectedly made a decision on his own to take a trip. He got on a plane, he took off, and he didn't come back. He left behind his business, his wife, and his son. All three miss him dearly, and all three are seeking closure. And even though Ms. Baja had nothing to do with Mr. Donaldson's decisions or his disappearance, Cam Donaldson has unfortunately brought her to court today. Cam Donaldson wants you to believe that Ms. Baja was responsible for his father's disappearance. But what this case really comes down to is that this case is a situation of misplaced blame. Now today, members of the jury, you have an important task before you. A few countries in this world call on their citizens to be the decision makers in their court system. But that's the duty and burden that you have here today. You get to make the decision. Now, the plaintiff, they came in with a different type of burden and duty, that one being the burden of proof. And they have that burden for good reason. It's because they're the ones that brought you to this courtroom today. And that burden of proof is that they have to prove all 4 elements of wrongful death to you by a preponderance of the evidence, more likely than not. That's what jury instruction number 7 tells you. And the plaintiff, just a moment ago, has tried to make it seem like they barely have a burden at all. But that's not the case. At the beginning of this trial, they started at 0%. And they had to provide and show evidence to you throughout trial to reach past 50%, to show more likely than not. Now, what that means is that they can't just prove their case by saying that Ms. Baja inherited money from Mr. Donaldson. That's not enough. And they can't just prove their case by relying on statements from Cam Donaldson about his suspicions about Ms. Baja. That is not enough. They had to provide more of a guidance to you for how this whole thing happened. But they weren't able to do that today. They weren't able to meet their burden. So what exactly were the hurdles that they had to clear for you today? Well, that's what jury instruction number 13 tells you. They had to prove to you 4 elements. 1, that Mr. Donaldson is indeed dead. 2, that Ms. Baja's conduct, either reckless or intentional, caused Mr. Donaldson's death. 3, that Cam Donaldson suffered harm from the loss of his father. And 4, that Ms. Baja caused that harm. Now, the most important and most difficult hurdle for them to clear was that one about Ms. Baja's conduct, causing Mr. Donaldson's death. Now, members of the jury, they weren't able to meet that element by a preponderance of the evidence today. Because what the plaintiff had to acknowledge is that there is no direct evidence showing that Ms. Baja caused Mr. Donaldson's death. There's no body, there's no DNA, there's no evidence of a crime scene or a murder weapon. There's no direct evidence at all. So what the plaintiff had to rely on today was what they believe are reasons and evidence of circumstantial situations and evidence of Ms. Baja's conduct. But let's go through each of those reasons and see what they really tell us, members of the jury. Now today, Ms. Baja took the stand, and she told you where she was in the period of August 17th to August 18th. Now, as the defense, we don't have a burden of proof, and Ms. Baja didn't have to tell you that information, but she did. She told you that night she was caring for some tiger cubs because they were abandoned by their mother. That was her devotion to her job. In the middle of the night, she ran out of formula, and so she went to the grocery store at 3 a.m. On the way back, her car broke down, and she had her brother take her home back to the Cubs. That's it. Mr. Donaldson wasn't involved. She didn't kill her husband during that time period. The plaintiff has provided no explanation as to how this crime or how Mr. Donaldson's death even occurred. We have no guidance, and they had to provide that to you, members of the jury. And it's not enough for Mr. Pyron to create a family connection for that Ms. Baja's brother was a police officer in order to indicate that there was bias in the police investigation. Besides that familial connection, we've heard no other evidence to indicate that there was any bias in that investigation. Now, they also want to hang their hat and rely on the events of August 19th, the day following, where they rely on Cam Donaldson's testimony that Ms. Baja somehow broke into the sanctuary and disposed of his father's will. Members of the jury, I want you to think carefully about that. Ms. Baja told you today that she works at that sanctuary. She has access to all of the facility there. She has keys. Why would she have any need to cut locks in order to access something there? Now, plaintiff wants you to believe that there was another will of Mr. Donaldson's in that location. But where is that other copy of that will? Does it make sense that a man worth several $1 million like Mr. Donaldson would only have one copy of that will, another copy, and there isn't another copy in, say, a safety deposit box in a bank or with an attorney who perhaps helped him draft it? That just doesn't make sense. Now, what the plaintiff truly wants you to rely on is a testimony of Taylor Pride saying that the will that was presented after Mr. Donaldson was declared dead was a forgery. But what did we really learn about Ms. Pride's analysis? Now, we learned today that people's signatures aren't exactly the same every single time that they write them. They can change little bits for various reasons. If you're writing it fast, or if a person's using a different pen than they usually do. And that makes sense. And that's why it's important when somebody's conducting a handwriting analysis to have more information rather than less, to have more recent sample signatures rather than older ones. You learned from Ms. Pride today that she had access to 4 different signatures of Mr. Donaldson's. But in her testimony to you today, she only compared it to 1. And in her report, she told you she only used 2 signatures in her comparison. She ignored one that was a signature of his that was written in May of 2012, just 2 months before Mr. Donaldson disappeared. Now, we have heard no testimony today that it's illegal for Ms. Baja to be a witness on a will in which she is the beneficiary of. We're not here to govern Mr. Donaldson's decisions on what he does with his money after his death. There's no evidence to support that this will was fraudulent. You heard from Chris Renard today, an insurance investigator and a document examiner, exactly that. The signatures, the verified signatures that she analyzed match the one on the will. Now, all the plaintiff truly has is potential motive. But even that doesn't hold up. Now, Mr. Pyron today spent a considerable amount of time asking about a woman like Ms. Baja. He asked her some questions in his cross-examination. He spent some time talking about it in his closing argument as well, about some decisions she made years ago when she first met Mr. Donaldson. Now, I want to emphasize to you members of the jury that your jury instructions, you will see if you look through them, nowhere does it say that the decisions that Ms. Baja made years ago is evidence, years ago, defying conventional norms is evidence of her being responsible for Mr. Donaldson's death. Nor is motive enough either. Even this potential motive that plaintiff has claimed Ms. Baja has doesn't hold up. And you learned today that no marriage is perfect. And Ms. Baja had her rough patches with Mr. Donaldson, and that was normal. They were communicating and they were working through it together. The plaintiff has painted Ms. Baja as this greedy person, but what we've heard testimony today is that even if Mr. Donaldson were to divorce her, she wouldn't be penniless. She would have still gotten a quarter of his inheritance. And if she truly was the greedy person that the plaintiff makes her out to be, why would she wait 5 years to present this will? It just doesn't make sense. Ms. Baja doesn't have a motive to cause Mr. Donaldson's death. And to this day, she is still there. She's taking care of their dream at the cat sanctuary. She hasn't moved and she hasn't remarried either. Now, like I said before, we as the defense, we don't have a burden of proof. And we could just end my closing argument right there because the plaintiff hasn't met theirs. But what I want to highlight to you, members of the jury, is a potential explanation that the plaintiff ignored. The possibility that Mr. Donaldson took one of his planes, took off, flew off, and just never came back. You heard testimony today that Mr. Donaldson owned several planes. He knew how to fly them. You heard testimony today that his van, just a week after he was declared missing, was found at a flight hangar. And it's not a crime for Mr. Donaldson to make a decision to go and fly somewhere and never come back. It's not a crime for Mr. Donaldson to never call or let anybody know where he's going. But this was a situation that the plaintiff ignored. Now, members of the jury, I would be remiss as Ms. Baj's attorney if I didn't address or comment on the demand of $2.25 million. Now, I want to remind you, members of the jury, that when instruction number 4 tells you how to assign damages, that the amount that you assign needs to be rationally related to the harm. The amount of $2.25 million just doesn't make sense. Mr. Donaldson could have made a decision to leave his money and do with his money as he pleases. He didn't have to leave that money to his son. And furthermore, Mr. Cam Donaldson, while we understand and sympathize with him about the loss of his father,
5 minutes, counsel.
He's an adult. He's no longer financially dependent on him. The amount of $2.25 million just doesn't make sense. Now, at the end of my closing argument, when you go back to your jury room to deliberate, you're going to be given verdict form number B. We're going to ask you to answer no, that Ms. Baja is not liable. And that's because even though everyone is hurting from Mr. Donaldson's loss, the unanswered questions about where Mr. Donaldson went, where he might have gone, or what happened to him does not show that Ms. Baja is legally responsible for Mr. Donaldson's disappearance. This is a case of misplaced blame. So we ask that you find Ms. Baja not liable. Thank you.
Thank you. Plaintiff have any rebuttal?
Yes, Your Honor.
Counsel, you have 2 minutes and 15 seconds.
Members of the jury, the willingness of this defendant to lie, forge documents, and cover up her crimes doesn't mean that the plaintiff loses this case. Her credibility is something else you get to consider. And when you decide this case, it's going to be about what's more likely than not. Is it more likely that a man left his son that he had a great relationship with to never be seen again? Or is it more likely that someone saw their golden ticket leaving and they decided they had to do something about it? That's what happened in this case. We found out what Karen's price was to do something so heinous. It was $10 million. Find her liable. Thank you.
Thank you. In that case, at that point, then the case will stand submitted. Congratulations. I thought you did a fabulous job on all sides. All right, I just want to check in with both parties. I'd love to talk and do more comments, but I think all the scoring panels have been writing long critiques and so on, so we'll get those filed. Anything else that you need from us before we go ahead and recess for the evening from the trial?
Great job, guys.
I do want to remind our 2 scoring panelists to make sure when you get to the end of the score sheet to hit submit on the end of that. We had a couple of people last night, I was told, who didn't click that right away, so we want your scores to count. Everyone, good luck in the future rounds. It was a pleasure watching the trial, and we'll be in recess for the evening. Thank you very much.
Thank you.
Good job, Justin.
Thank you all. Good job.
Elizabeth. Thank you for your time.
Good job,
You too.
everyone.
Good job, everyone.